Morning, friends. This is Rishikesh from Team BVKS. Today, BVKS and Mumbai Insurance Institute have arranged a session on marine insurance by our distinguished speaker, Punit Pandya sir. Punit sir is currently posted in non-suit claims of Surat as an assistant manager. He is looking after fire, engineering, marine, and miscellaneous claims. We are eagerly anticipating a riveting and enlightening lecture that Punit sir will deliver with his great expertise. Thanks to our leader Dinesh Bobade sir, our team members Mr. Sachin Lokesh sir, Anil Jadhav sir, and Jivan Bhosle sir for their efforts in arranging these scholarly lectures with sea of knowledge. Over to you, Punit sir. Thank you.
Am I audible?
No. So?
Yes, sir. Yes, sir.
Okay. Give me 2 minutes, please. Good morning, everyone. Am I audible?
Yes, sir.
Okay. So Mr. Rishikesh, how can I share my PPT? Is this PPT visible to everyone?
No, sir.
No, sir.
No, sir.
Okay. So should we start?
If it is not visible, sir.
Okay. So as we all know, marine insurance is, of course, one of the oldest form of insurance.
Sir, please share your screen.
Okay. Is it okay now?
Yes, sir. Abhi visible
Sir,
hai.
now we can see.
Okay. So as we all know that the marine insurance is one of the oldest form of insurance. Of course, the modern form of marine insurance is way different than what we used to practice in the ancient time. We cannot say that the ancient form of insurance was exactly same as the modern form of insurance. It was more of a risk transfer in form of interest, which we today call as a premium. Okay, so it is of course oldest form of insurance. We have found reference of marine insurance in various ancient literature like Aryan literature, old Chinese literature, and many other literatures. So there was in ancient India, there was a concept of jokhmi hundi. Now the word jokhmi means risk. Jokhim means risk. And hundi is nothing but as we call it today, a letter of credit. Okay, so it's a form of bill of exchange or a letter of credit. So the term jokhmi has come from the word Hindi word jokhim, which means risk. There used to be many types of hundi. I guess 10 or 11 type of hundis. These all hundis were nothing but one or other form of bill of exchange, one kind of financial tool. So jokhmi hundi is a combination of bill of exchange and an insurance policy payable only when the goods reach in safe and secure condition. If anything wrong happens to the goods during the transit, the consignor cannot claim payment of hundi from the consignee. Thus, a jokhmi hundi safeguards the interest of both the parties. It acts as a bill of exchange if the goods arrive securely and if the goods are lost, destroyed in transit. Such a bill acts as an insurance cover. So what happens is a consignor raises a jokhmi hundi in favor of consignee. So if the goods arrives to the consignee in a safe condition, in a sound condition, then the consignee, that is the receiver of the goods, will honor the hundi along with the interest. So if the principal amount of the hundi is 100 rupees, say 100 rupees, and if the interest amount is 10% or we can say 10 rupees, so when the consignee receives the goods in sound condition, he will pay 110 rupees to the consignor. So that 10 rupees extra can be considered as premium. Of course, it is not consistent with the present day principle of 64 VB. When we collect the premium in advance and then we issue the insurance policy and we pay the claim subsequently. So it is completely different. We can say the interest, which is, we can set an analogy with today's premium amount. The interest amount used to be paid subsequently when the goods arrived in sound condition. So what if the goods are destroyed or damaged during the transit? The consignee is not supposed to honor the hundi. And then that can be termed as a claim amount. We can compare it with the claim amount that since he has not received the goods in sound condition, he is not supposed to honor the hundi and he is not supposed to pay to the consignor. Then we have Hammurabi's code in Babylon. If a merchant, it is completely same as jokhmi hundi. If a merchant's goods did not arrive at destination safely, the debts incurred to finance the transaction were to be written off. Bottomry and respondentia bonds are also identical. They were used in Europe. Loans were raised to generate finance to prosecute the voyage by mortgaging the ship, and if the ship or cargo were lost, there was no need to repay the loan. But if they reached safely, a part of profit was to be paid to the money lender. Bottomry bonds were used to execute for hull insurance, or we can say to secure a hull and machinery or a vessel, and respondentia bonds against cargo or goods. First type of insurance transacted in the world around 1310 AD, oldest and earliest marine insurance policy in its modern form, relates to a Mediterranean voyage in 1347, spread from Italy to the trading routes in Europe. In the year 1400, a merchant in Florence wrote a book wherein premium rates for shipment from London to Pisa were mentioned. The Italian merchants from Lombard were then experts in marine insurance business who finally settled in London to do business, and the area was called Lombard Street. So the Lombard Street was actually founded by Italian merchants from Lombard, who were experts in marine insurance business. The insurance originated in coffee house owned by Edward Lloyd's on Tower Street, where ship owners, charterers, seafarers, shipbrokers, marine underwriters, etc. used to sit and discuss their business. So this fellow, Edward Lloyd, used to have a coffee house in Tower Street. And it was just a normal coffee house, but he noticed one interesting thing, that many maritime professionals like ship owners, ship brokers, custom brokers, freight forwarders, seafarers, and many other maritime professionals used to visit his coffee house, and they used to discuss many things. So back then, since there were no many means of information exchange, and of course there was no internet, there was no such mediums for transacting the information, vital information related to maritime adventures. So what he did, he started, he put a blackboard in his coffee house, and he started writing all these information he used to hear from all these maritime professionals, that this ship has arrived at this place, this ship is going to departure from this place, this ship has encountered so and so problems, this ship has sank at this place, and he used to write down all these information on that blackboard. And this simple strategy has got him so many maritime professionals as his customers, and people started visiting his coffee house, not just to enjoy the coffee, but to get all this information, which were very vital in transacting their business. So that's how the Edward Lloyd's coffee house became very famous. Thus, this branch of insurance flourished in UK, where Historic Lloyd's Association was founded in 1692. The Lloyd's List, a bulletin containing details of ships, was published and circulated from 1696. It is now converted into a, we know, Lloyd's Shipping Register. This is the oldest magazine in Guinness Book of World Records. In 1871, the first Lloyd's Act was passed in UK's Parliament, which gave the business a sound legal footing. So up till 1871, yes, there were association, Lloyd's Association. Pardon. There were Lloyd's Association. There were groups, there were syndicates at Lloyd's market, but there was no, any particular statute or legal framework or any regulation which can govern these market. I mean, the market was very scattered. It was not well governed or regulated by any statute. So in 1871, the first Lloyd's Act was passed in UK's Parliament, which gave the business a sound legal footing. The Marine Insurance Act 1906 was passed in UK's Parliament, and subsequently in India, we have Marine Insurance Act 1963, which is literally the replica of MIA 1906. It is one of the most flexible act. Now, this is a very important aspect of this act, Marine Insurance Act 1963. Why it is written like this, that the Marine Insurance Act is one of the most flexible act, we will see subsequently, because you will usually find almost in every section you will find phrases like unless otherwise specifically excluded, or unless otherwise prohibited in the policy schedule, or subject to return anything contrary in the policy schedule. You will find such type of phrases mentioned almost in every section of the Marine Insurance Act. That's why I'm saying that the Marine Insurance Act is one of the most flexible act, because if anything is prohibited in policy schedule, if anything is written something contrary to the Marine Insurance Act 1963, the wording of policy will supersede the Act of Parliament itself. So the provision of the Marine Insurance Act will not apply, but if something contrary is written in the policy schedule, that policy wording will supersede. Someone cannot argue that, look, your policy is saying something else, however, something contrary is written in Marine Insurance Act. No, because there are phrases like unless otherwise specifically excluded in the policy schedule, unless otherwise specifically prohibited in policy schedule, this section says so and so. So the provision of this, that particular section will only be applicable if it goes consistent with the policy wording. If it does not go consistent with the policy wording, the policy wording will always supersede. Okay. You can simply ask any doubt, any question in between. Okay. You can simply raise your hand and ask the question. Principle of Marine Insurance Act. Now we'll look at the principle of marine insurance, how they are different with other line of property and casualty business. What are the additional principles which are applicable for marine insurance? We will also look at these principles from the perspective of Marine Insurance Act 1963. Okay. Hold a minute. So the first principle is principle of utmost good faith. Like any other line of business of insurance, the marine insurance is also subject to principle of utmost good faith. What are the sections of Marine Insurance Act which deals with the principle of utmost good faith? So section 19 to section 23 of Marine Insurance Act deal with the principle of utmost good faith. We'll look at all these sections one by one. Section 19. Insurance is uberima fide. It's a Latin phrase which means a contract of marine insurance is a contract based upon the utmost good faith. And if the utmost good faith be not observed by either party, the contract may be avoided by the other party. So the obligation of utmost good faith has been imposed on both the parties. Who are the parties to the contract of insurance? The insured as well as the insurer. So both are obliged to observe the principle of utmost good faith. Usually we think that the principle of utmost good faith is only applicable to the insured. No. Principle of utmost good faith is equally imposed on the insurance company as well. That means the insurance company is also supposed to observe this principle. He's also supposed to make full disclosure. Full disclosure of what? Full disclosure of policy terms, conditions, policy access, coverage, what will be the warranties, terms and conditions. So if the insurance company also failed to comply with the requirement of this principle, the insured can take this plea and the decision will be in the favor of the insured. So a contract of marine insurance is a contract based upon utmost good faith, and if the utmost good faith be not observed by either party, the contract may be avoided by the other party. Section 20, disclosure by the insurer. Subject to the provision of this section, the assured must disclose to the insurer before the contract is concluded every material circumstance which is known to the assured, and the assured is deemed to know every circumstance which in the ordinary course of business ought to be known to him. If the insured fails to make such disclosure, the insurer may avoid the contract. So this section is very important from the perspective of the insurance company. This section imposes an obligation on the insured that he's not only supposed to disclose only those facts which for which the insurance company has inquired about, or for which a question has been incorporated in the proposal form or in any other form of declaration. Okay, so even if the insurance company has not asked for any particular fact or any particular question in the proposal form, if it is material to the proposal, and even if it is not asked by the insurance company, it is an obligation of the insured to disclose all such material facts or material circumstances to the insurance company. And then there is one more clarification. The assured is deemed to know every circumstances which in ordinary course of business ought to be known to him. If the assured fails to make such disclosure, the insurer may avoid the contract. Okay, so if the insured comes to you and he wants to insure his chemicals, okay, now the chemicals are extremely inflammable, they are extremely hazardous, they may pose liability, pollution liability, and there are no such question in your proposal form or your questionnaire that whether the chemicals are hazardous or they are extremely inflammable or they are having flash point below 10 degree or 30 degree. But the insured must disclose all these facts to the insurance company. Further, the insured cannot say that I didn't know that these are hazardous chemicals or these are highly inflammable chemicals. No, because he is engaged in the business of manufacturing, or you can say trading of hazardous chemicals, highly inflammable chemicals. He is engaged in that particular business. So he is deemed to know these circumstances. Because in an ordinary course of business, you must know all these circumstances, that what are my goods, what are the properties of my goods, what are the perils or hazards to which my goods are susceptible. So you are supposed to know all these facts. Okay. Now, what is the definition of material circumstances or material facts? Subsection 2 says every circumstance is material which would influence the judgment of a prudent insurer in fixing the premium or determining whether he will take the risk or not. So, for the sake of clarity and to eliminate all the ambiguity, the term material circumstance or material fact has been defined in the Act itself. Any circumstance is material which would influence the judgment of prudent insurer in fixing the premium. So anything which can affect the decision of an insurance company, that whether they will accept the risk or not, or if they are at all willing to accept the risk, at which premium amount they are going to accept the risk, that circumstance or that fact can be considered as a material fact. In the absence of inquiry, now this is an exception. So what are the kind of facts, or what are the kind of circumstances which an insured is not supposed to disclose? So this is an exception to the principle of utmost good faith. So in the absence of inquiry, so if the insurance company does not ask for any following the following facts, the insured is not supposed to disclose them. Which are these circumstances? Any circumstance which diminishes the risk. So it's a matter of common fact or common sense. You can say that any circumstance which increases the risk can be termed as material fact. But anything which decreases the risk, which diminishes the risk, the insurance company will not bother if you do not disclose them, because in any way it is going to diminish the risk and it is in favor of the insurance company. So any circumstance which diminish the risk, the insured is not supposed to disclose that circumstance. Any circumstance which is known or presumed to be known to the insurer is presumed to know matters of common notoriety or knowledge, and matters which on insurer in the ordinary course of his business as such ought to know. Okay. So any fact or any circumstance which is a matter of common knowledge, which is widespread, which is commonly known by each and everyone, or you can say that an insurance company in ordinary course of his business is ought to know such facts. The insured is not supposed to disclose all such facts. Okay, so one insured comes to you and that insured says that, look, my consignment is going to Russia and I want coverage of ICCA plus war and SRCC. Okay, you have given them coverage of ICCA, war and SRCC. The consignment reaches the Russia, and then due to ongoing war between Russia and Ukraine, the consignment was damaged. Now, subsequently, insurance company cannot take a plea that you have not disclosed that there is a war between Russia and Ukraine. No, it's a matter of common fact. I mean, everyone in the world knows that there is a war between Russia and Ukraine. So the insured is not supposed to disclose this. Any circumstance as to which information is waived by the insurer, and any circumstance which is superfluous to disclose by reason of any express or implied warranty. Sorry. Subsection 4 says, whether any particular circumstance which is not disclosed be material or not, in each case is a question of fact. So there cannot be a thumb rule regarding material fact or material circumstances. Each and every circumstance has to be dealt with on merit, and it's a question of fact. So a particular scenario can be a material for a particular type of transit, but it cannot be material for any other type of transit. Okay. The term circumstance include any communication made to or information received by the insured. Section 21, disclosure by agent affecting insurance. Subject to the provisions of preceding section, as to circumstances which need not be disclosed, where an insurance is effected by the assured, effected for the assured by an agent, agent must disclose the insurer every material circumstance which is known to himself, and an agent to insure is deemed to know every circumstance which is in ordinary course of business or to be known by or to have been communicated to him, and every material circumstance which is the assured is bound to disclose unless it comes to his knowledge too late to communicate it to the agent. Now this is one very interesting section. Apart from the insured and the insurance company, this is the only class of insurance where the obligation of utmost good faith has been imposed on the agent of the insured as well. An agent of the insured who is effecting insurance policy on behalf of the insured is also under the obligation to disclose every material circumstance which is known to him. Section 22 says representations pending negotiation of contracts. So what are the type of representations? Every material representation made by the assured or his agent to the insurer during the negotiation of the contract and before the contract is concluded must be true. If it is untrue, the insurer may avoid the contract. A representation is material which would influence the judgment of a prudent insurer in fixing the premium or determining whether he will take the risk or not. A representation may be either as to matter of fact or as to matter of expectation or belief. A representation as to matter of fact is true if it is substantially correct. That is to say, if the difference between what is represented and what is actually corrected would not considered material by a prudent insurer. A representation as a matter of expectation or belief is true if it is made in good faith. A representation may be withdrawn or corrected before the contract is concluded. Whether a particular representation be material or not is in each case matter of fact. Now again, what are the types of representation as per the Marine Insurance Act? So a representation can be matter of fact or matter of expectation or belief. Okay, so if a representation is a matter of fact, it has to be substantially true. If it is not true, and what has been declared and what actually is the scenario, the difference between these two is material to an underwriter. The insurance company can outrightly disclaim their liability. The insurance company, if you have disclosed that my commodities are ABC and ultimately it turns out to be XYZ, and the entire properties, entire formations, entire associated perils and hazards with these goods are completely different. What were the declarations made by the insured as well as what the actual fact is. So this is considered as a representation which is a matter of fact. So if the representation is matter of fact, it has to be substantially true. The difference between what has been declared and what is the actual fact should not be material to the insurance company. Okay. Now, the second thing is representation made in expectation or belief. So if a representation is a matter of expectation or belief, if it shall be considered as true if it is made in good faith. For example, if one of your insured is importing one consignment from abroad, okay, he has made a declaration that my consignment is going to sail on 1st September. 1st of September 2023, my consignment is going to sail from Dubai. Now what happens is the consignment actually sails on 10th of September instead of 1st September. There is a delay of 10 days. So it's a representation which is a matter of expectation or belief, because your insured has made this representation or made this declaration on the basis of information provided by the seller, overseas seller, or his consignor. His consignor has said that your consignment is going to be sailed on 1st of September, and accordingly your insured has made such declaration, such representation. So if the consignment sails on 10th of September instead of 1st of September, you cannot avoid your liability that your declaration is wrong, because that declaration is a matter of expectation or belief, and it was made in good faith. The assured has no control whatsoever on such type of representation, on such type of declarations. So the insurance company cannot take a plea of breach of utmost good faith, breach of prima fide, that the representation made by you is incorrect. So any representation which is a matter of expectation or belief is considered as true. It is considered as true if it is made in good faith. A representation can be withdrawn or corrected before the contract is concluded, of course. And whether a particular representation be material or not in each case is a question of fact. There cannot be a thumb rule. You have to decide on the merit of each and every case that whether the fact or the representation declared by the insured is material or not. Okay. Section 23, when contract is deemed to be concluded. A contract of marine insurance is deemed to be concluded when the proposal of the assured is accepted by the insurer, whether the policy be then issued or not. And for the purpose of showing when the proposal was accepted, reference may be made to the slip, covering note, or other customary memorandum of contract, although it be unstamped. Now, more or less, nowadays, this particular section is redundant. I mean, it is not much of a use, because we all know nowadays how we conclude a contract or how we finalize a proposal form through emails, we have electronic mode of fund transfer and all those facilities. So this particular section is not much important. Warranties. Section, now the warranties can be termed as a corollary principle or a sub-principle of utmost good faith. Okay, so it's not a full-fledged principle in itself, but you can say that the principle of warranties is a corollary principle to the principle of utmost good faith. Warranties. Section 35 to 43 of Marine Insurance Act deals with warranties. Section 35, nature of warranty. A warranty in the following sections relating to warranties means a promissory warranty. That is to say, a warranty by which assured undertakes that some particular thing or shall or shall not be done, or that some condition shall be fulfilled, or whereby he affirms or negatives the existence of a particular state of facts. What is the purpose of a warranty? A warranty safeguards the interest of an insurance company. Why do we incorporate warranties in our insurance policies? Because when we accept the risk, we want to make sure that particular state of affairs or particular status should be maintained throughout the policy schedule to safeguard our interest. Because when we accept a proposal form based on the declarations made by the insurance by an insured, based on the facts disclosed by an insured, we want to make sure that the facts, the features, the good features or the circumstances on the basis of which we are going to accept the risk must be maintained throughout the policy period. And if the insured fails to maintain that state of affair throughout the policy period, we as an insurer can avoid our liability. So this is the definitions. The subsection 1 of 35, section 35 gives the definition of warranty. A warranty by which assured undertakes that some particular thing shall or shall not be done, or that some condition should be fulfilled, or whereby he affirms or negatives the existence of a particular state of facts. So if an insured declares that 100% of my consignment is going to be full container load containerized cargo, FCL containerized cargo. Okay. Now the containerized cargo are considered as a good risk as compared to brick bulk cargo, as compared to bulk cargo, or as compared to liquid cargo, any other form of cargo. Containerized cargo is considered as a very good risk. So he has declared that 100% of my entire turnover is going to be FCL. FCL means full container load. FCL containerized cargo. So it is considered as a very good risk. So on the basis of this fact, you have accepted the risk. You have charged premium, which is usually lower than you are going to charge for any other form of cargo. So you will incorporate a warranty that warranted only containerized cargo being covered. Only FCL containerized cargo being covered. So if in case he sends a consignment in brick bulk, in wooden pallets, or in any other form of packaging other than containerized, that particular consignment shall fall outside the scope of policy coverage. A warranty may be express or implied. Express warranties are those warranties which are explicitly mentioned in your policy contract. Okay. And implied warranties are those warranties which are incorporated in Marine Insurance Act 1963. So even if you do not incorporate those warranty in your policy wordings, policy contract, they also exist simultaneously along with express warranties. A warranty, as above defined, is a condition which must be exactly complied with, whether it be material to the risk or not. If it be no so complied with, then subject to any express provision of in the policy, the insurer is discharged from the liability as from the date of breach of warranty, but without prejudice to any liability incurred by him before that date. So this is the difference between a warranty and a condition. One might be wondering what is the difference between a warranty and a condition. So insured is supposed to comply with warranties as well as conditions of the policies. However, a condition, an insurance company can take shelter of a condition or can invoke a condition only if breach of the condition is material to the loss. When I say material to the loss, that means breach of the condition has contributed in any way to the loss, whether it is a cause of loss or whether the breach of condition has aggravated the loss. So insurance company can take shelter of a breach of condition only if the breach of condition is material to the loss. If it is completely immaterial to the loss, if it is completely alien to the loss, it is not at all contributing towards the loss, insurance company cannot take the shelter of breach of condition, that you have violated this condition. Contrary to this, a warranty must be complied with exactly, irrespective of whether it is material to the risk or not. So if there is a breach of warranty, even if it is completely immaterial to the loss, the insurance company can avoid their liability. When breach of warranty is excused. So when there is a breach of warranty, but there is exceptions that these are the circumstances where the breach of warranty can be excused. Non-compliance with a warranty is excused when by reason of change of a circumstances, the warranty ceases to be applicable to the circumstances of the contract. Or when compliance with the warranty is rendered unlawful by any subsequent law. So, when you have incorporated warranty and subsequently there is any regulatory change by any government, semi-government or any local body, which has rendered the compliance of warranty unlawful, then you cannot take a plea that this warranty has been breached or not complied with. For example, you have incorporated a warranty regarding packaging that these goods must be packed, warranted goods being packed in jumbo plastic bags. This is a kind of warranty regarding packaging, that the goods must be packed in jumbo plastic bags. Now the government has banned use of jumbo plastic bags, that no one should use these jumbo plastic bags. They are harmful to environment. So we are banning it. Now, the insured cannot adhere to the law as well as comply with the warranty simultaneously. It is not possible for them. So, he has started using any other form of packaging. So, yes, of course, there is a breach of warranty, but you cannot say that there is a non-compliance, because in that case, the breach of warranty is excused. Where a warranty is broken, the assured cannot avail himself of defense that the breach has been remedied and the warranty complied before the loss. Again, the same principle that the warranty must be complied with throughout the policy tenure. If the warranty has breached once and it was remedied subsequently, or he has complied with the warranty subsequently, even before the loss, the insurer cannot avail himself of this defense, because it has to be complied with invariably, whether it is material to the loss or not. A breach of warranty may be waived by the insurer. So if the insurance company itself waives the breach of warranty, then the breach of warranty is considered as excused. Express warranties. So what are the express warranties? An express warranty may be in form of words from which intention to warrant is to be inferred. An express warranty must be included in or written upon the policy, or must be contained in some document incorporated by reference to it. An express warranty does not exclude implied warranty unless it be inconsistent therewith. So, express warranty shall be read in conjunction with implied warranty, unless and until both the warranties are contradictory in nature, they are contrary to each other. In that case, the express warranty will, of course, supersede the implied warranties. Warranty of seaworthiness of ship. Again, this is one of the implied warranties. Even if you do not incorporate this warranty in your policy schedule, it is deemed considered as being incorporated in the policy, and you can simply take plea of this warranty that this warranty has been breached. Warranty of seaworthiness of ship. So in a voyage policy, there is an implied warranty that at the commencement of the voyage, the ship shall be seaworthy for the purpose of particular adventure insured. So it's an implied warranty that at the commencement of the voyage, the ship shall be seaworthy for the purpose of particular adventure insured. Where the policy attaches while the ship is in port, there is also implied warranty that she shall, at the commencement of the risk, be reasonably fit to encounter the ordinary perils of the port. Where the policy relates to a voyage, which is performed in different stages. For example, there are transshipment to a particular voyage, during which the ship requires different kinds of or further preparation or equipments. There is an implied warranty that the commencement of each stage, the ship is seaworthy in respect of such preparation or equipment for the purpose of that stage. So if a ship is to complete her journey in multiple stages, in multiple transshipments, then it's an implied warranty that the ship must be seaworthy at the commencement of each journey or each transit. A ship is deemed to be seaworthy when she is reasonably fit in all respects to encounter the ordinary perils of seas of adventure insured. In a time policy, there is no implied warranty that the ship shall be seaworthy at any stage of the adventure, but where with the privity of the assured, the ship is sent to sea in an unworthy state, the insured is not liable for any loss attributable to unseaworthiness. No implied warranty that goods are seaworthy. So there is no such implied warranty that the goods are seaworthy. The ship, the vessel carrying the goods must be seaworthy. But in a policy on goods where or other movable, there is no implied warranty that the goods or movables are seaworthy. In a voyage policy on goods or other movables, there is an implied warranty that at the commencement of voyage, the ship is not only seaworthy as a ship, but also that she is reasonably fit to carry the goods or other movables to the destination contemplated by the policy. So yes, there is one implied warranty that the ship which is carrying the goods must be seaworthy and reasonably fit to carry the goods. So the ship should be reasonably fit or adequately fit to carry the goods which we are going to cover. For example, if you are going to import or export crude oil, so it must be carried in a tanker, a vessel called tanker. You cannot carry a bulk oil or bulk crude oil in any other ordinary form of ship. So it should be reasonably fit to carry the goods. Warranty of legality. There is an implied warranty that the adventure insured is lawful one, and that so far as the assured can control the matter, adventure shall be carried out in a lawful manner. So we are not supposed to insure any illegal or any contraband substance which are rendered illegal or unlawful by the concerned authorities or government authorities. So it's an implied warranty. Even if it is not written anywhere in the policy schedule, it will always prevail that the adventure must be lawful. Now, the principle of insurable interest. Section 6 to 17 of Marine Insurance Act 1963 deals with the subject of insurable interest. What is the definition of insurable interest? Subject to the provision of this act, every person has an insurable interest who is interested in marine adventure. In particular, a person is interested in marine adventure where he stands in any legal or equitable relation to the adventure or to any insurable property at risk, wherein the consequent of which he may benefit by safety or due arrival of insurable property, or may be prejudiced by its loss, or by damage thereto, or by the detention thereof, or may incur liability in respect thereof. So, what can be the parties who has insurable interest in any marine adventure? So, of course, seller who is sending his goods, he has insurable interest. Buyer who is going to receive the goods, who has already made some advance payment, or who is going to make payments for that consignment, he is supposed to have insurable interest in a maritime adventure. A bank or finance company who has financed the entire adventure can be termed as one of the interested parties. Again, there will be circumstances where the freight are not paid fully in advance. So in that case, the shipping company who is under the expectation of receiving freight for one particular consignment can be termed as interested party in a maritime adventure. When interest must attach. So the assured must be interested in subject matter insured at the time of loss, though he need not be interested when the insurance is affected. So this is again major point of difference between marine insurance and other LOBs. In other LOBs, insurable interest must exist at the time of arranging the insurance policies. It must exist throughout the policy period, and it must exist at the time of loss as well. However, that is not the case here in marine insurance. In marine insurance, the assured must be interested in the subject matter insured at the time of loss only, even though he had no insurable interest at the time of effecting the insurance policy. Provided that where the subject matter is insured, lost or not lost, the assured may recover, although he may not have acquired his interest until after the loss, unless at the time of effecting the contract of insurance, assured was aware of the loss and the insurer was not. So what is this phrase, lost or not lost? This phrase says that, for example, the journey has already started and the insured has not arranged insurance policy. So can he arrange insurance policy subsequently? So the answer is yes, provided he is completely unaware of the present state of affair or present status of the consignment, whether there has already been any loss or not. If this knowledge has already been known to, this fact has already been known to the insured, that my goods or my consignment has already been damaged and there is no insurance policy in place, and then he approaches the insurance company for the insurance policy, in that case the policy will be null and void. So the insured can arrange insurance even after the loss has occurred, provided he is not aware of the status of the consignment or he is not aware of the fact of the loss at the time of effecting the insurance policy. Where the assured has no interest at the time of loss, he cannot acquire interest by any act or election after he is aware of the loss. So when the insured comes to the fact that the goods are already lost or the goods are already been damaged, then he cannot subsequently acquire the interest by any act or any election. For example, a seller sends his consignment to the buyer on X works basis. So as far as X works is concerned, the seller's responsibility is simple. He's only supposed to he's only supposed to pack the consignment. He's only supposed to keep the consignment ready for dispatch at his doorstep to the buyer. So he has no insurable interest during the transit. Okay. So if the goods are collected by the buyer and the buyer is transporting the goods from seller's warehouse to the port of loading, and in between there is a loss to the consignment, the goods are lost or destroyed. Now at this point of time the seller has no insurable interest, so subsequently he cannot change the Incoterms from X works to FOB or C&F or CIF, and he cannot claim that since my Incoterms are C&F and CIF, I have insurable interest till the free on board point or FOB point. No, he cannot do this subsequently. If the original term of delivery, if the original term of sale were X works only, he cannot subsequently change the Incoterms or contract of delivery and acquire the insurable interest. Defeasible or contingent insurable interest. A defeasible interest is also insurable as well as contingent insurable interest. A defeasible interest is one which can be brought to end during the currency of insurance by occurrence of some event other than maritime perils. So what is defeasible interest? In Incoterms, we know that there is a point of delivery. Okay. In each and every type of Incoterms, we know that there is a point of delivery. That means after that point, the risk passes from the seller to the buyer. So now the seller no longer have interest in the goods. The seller is not at all at risk, and the entire risk has been passed to the buyer, and the buyer acquires the interest. So this phenomena, for example, in CIF, C&F, and FOB, in all these three Incoterms, the point of delivery is free on board, FOB point. What is FOB point? The FOB point is considered when the goods passes the ship's rail and placed safely on board the vessels. When the goods passes the ship's rails and placed safely on board the vessel, it is considered as the free on board points or FOB point. So at FOB point, no, it's not a maritime peril. It's not any event which is considered as a maritime peril. It is simply a delivery. So in this occurrence or in these circumstances, interest of seller ceases and interest of the buyer attaches. So a defeasible interest is one which can be brought to an end during the currency of the insurance by occurrence of some event other than maritime perils. What is contingent interest? A contingent interest that attaches during the currency of a voyage on the happening of a contingency. If some contingency happens, then the interest attaches during the currency of voyage. It is considered as contingent interest. What is the definition? What is the best example of contingent interest? Your sailor's interest policy or your sailor's contingency policy. It is the best example of contingent interest. In short, we will look at this sailor's interest or sailor's contingency policy subsequently, but for the time being, what happens in sailor's contingency policy, when a seller sends his goods on FOB and C&F Incoterms, after the FOB point, his interest ceases to exist. Okay. So if the goods are sent on credit, after FOB point, his insurable interest terminates, and if the payment is pending, and if the buyer receives the goods in damaged condition, if the goods are destroyed before the buyer collects the goods, he will reject the goods. That, I have received the goods in damaged or destroyed condition, I'm not going to accept this. Now the seller has lost his insurable interest. The seller has not received his payment from the buyer. The seller's goods are also lost or destroyed during the transit. So he has no remedy in this case. He cannot claim any payment or any amount from any party, either from a buyer or from the insurance company. So by attaching seller's contingency clause or seller's interest clause in your marine policy, which is a best example of contingent interest, the insurable interest of seller reattaches during the transit. Okay, so we will look at this insurance policy subsequently in detail. In particular, where the buyer of goods has insured them, he has an insurable interest, notwithstanding that he might, at his election, have rejected the goods or have treated them as seller's risk by reason of letters delay in making delivery or otherwise. Assignment of insurance policy. Now, this is again corollary principle of insurable interest. This is one more area from where the marine insurance is marine insurance can be differentiated from other LOBs, because we do not find the assignment of policy, assignment of goods in other assignment of insured property in other form of LOBs. Section 70, section 52 and 53 are concerned with assignment of policy. Marine insurance policies are freely assignable unless specifically prohibited, but assignment is not automatic. Now, this is again, unless specifically prohibited. Not all the marine insurance policies are freely assignable. So section 52 says when and how the policy is assignable. A marine policy may be transferred by assignment unless it contains terms expressly prohibited the consignment. Now, these are the phrase. This is the example. Unless it contains terms expressly prohibiting the consignment. Now, this phrase makes this section very flexible. A marine policy may be transferred by assignment unless it contains terms expressly prohibiting assignment. It may be assigned either before or after the loss. Now, what are the examples of policies in which assignment is not permissible? Seller's contingency, seller's interest policies, buyer's contingency or buyer's interest policies, increased value insurance, duty insurance, annual policies or inter-depot transfer policies. These are the policies in which assignment is not permissible. We'll look at all these policies subsequently. And we will look at the reasons why assignment is not permissible in all these policies. Where a marine policy has been assigned so as to pass the beneficial interest in such policy, the assignee of the policy is entitled to sue thereon in his own name, and the defendant is entitled to make any defense arising out of contract which he would have been entitled to make if the suit had been brought in the name of person by or on whom behalf the policy was effected. So, only the goods are not assigned to the assignee, not only the goods or benefits under the insurance policy. The assignee can also sue the insurance company in a court of law, just like the person or the insured who has effected the insurance policy, who has obtained the insurance policy. So he not only he can claim benefit under the insurance policy, he can also bring the insurance company in a court of law. He can also file suit against the insurance company, just like the person, just like the insurer who has obtained the insurance policy. A marine policy may be assigned by endorsement thereon or in any other customary manner. There is no any defined or any stipulated format in which assignment should be made. Marine policy can be assigned by any customary manner. Assignment of interest. Section 17 says, where the assured assigns or otherwise parts with his interest in the subject matter insured, he does not thereby transfer to the assignee his rights under the contract of insurance unless there be an express or implied agreement with the assignee to that effect. So this point, marine policies are freely assignable. That is completely true. Unless otherwise there is a explicit prohibition under an insurance policy, marine insurance policies are freely assignable. But the assignment is not automatic. There has to be some sort of agreement between the seller and the buyer to make the assignment possible. Further, the assured cannot assign after he has parted his interest with the subject matter insured. And the assignment is also not automatic. So, if the seller is sending his goods to his buyer on C&F and FOB basis, cost and freight, or free on board Incoterms basis, he is sending his good to his buyer. And after FOB point, that is after point of delivery, before the point of delivery, he has not assigned his insurance policy in the name of buyer. Okay, he has forgotten to assign the insurance policy in the name of buyer before the point of delivery. So after the point of delivery, when he has already lost his insurable interest in the insurance policy, where he has already delivered his goods, where he has already parted his ways with the goods, he cannot subsequently assign the insurance policy to the buyer unless there is a explicit agreement between the between the seller and the buyer. So one example is CIF, cost insurance and freight Incoterms. Now, what does this Incoterm say? This Incoterm says there is an obligation on the seller to arrange insurance on behalf of buyer, at least up to the port of discharge. So there is an obligation, there is an explicit agreement between the seller and the buyer to arrange insurance on behalf of buyer. So the seller will arrange insurance on behalf of buyer. So even if there is no explicit assignment in favor of buyer, the insurance policy is termed as assigned in favor of buyer after the FOB point automatically. So the buyer purchases goods from the seller on CIF basis, where there is an obligation on the seller to arrange insurance cover against the buyer's risk for loss or damage of the goods from the port of shipment to at least the port of destination. This will be considered as an express agreement between the seller and the buyer. And by virtue of this express agreement, the assignment will be automatic in such scenario. Section 53 says, assured who has no interest cannot assign. Where the assured has parted with or lost his interest in the subject matter insured and has not before at that time of so doing expressly or impliedly agreed to assign the policy, any subsequent assignment of the policy is inoperative. This is a matter of common sense. If you have no insurable interest at the time of assignment, how can you assign the policy to someone else? Okay, so to assign the policy at the time of assignment, you must have insurable interest in your goods. You must have interest in your goods, in your policy. Then only you can assign your policy to someone else or to your buyer. So where the assured has parted with or lost his interest in the subject matter insured, and before that point of time, he has not expressly or impliedly assigned the policy, he cannot do subsequently. Provided that nothing in this section affects the assignment of a policy after a loss. Yes, you can assign the policy after a loss, provided at the time of loss you had insurable interest. At the time of loss, you have not parted with the goods, you have not lost interest in your subject matter insured. So even if there is a loss, you can assign the policy subsequently. The seller is sending goods on FOB and CFR term or C&F terms of delivery, according to which the seller is deemed to have delivered the goods once the goods passes the ship's rail and placed safely on board the vessel. The seller has insured the goods only up to FOB point. The seller cannot assign the insurance policy in favor of buyer after FOB point. He can assign the policy before the FOB point, but he cannot assign the policy after the FOB point. Because after the FOB point, the risk has already been transferred from seller to buyer. He has already lost interest in the goods. Principle of indemnity. Unless otherwise specifically prohibited. Again, look at this phrase. Unless otherwise specifically prohibited, the marine policies are valued policies. Section 29 says a policy may be either valued policies or unvalued policy. A valued policy is a policy which specifies the agreed value of the subject matter insured. So, at the time of affecting a marine insurance policy, we usually ask for a basis of valuation. So, this principle of valued policy says that at the time of effecting the insurance, the insured will propose one basis of valuation and the insurance company will accept that basis of valuation. And this particular property makes it a valued policy. So what is the basis of valuation? Basis of valuation says that at the time of loss, what will be the amount that will be paid to the insured by the insurance company. Okay, it could be anything. It could be cost only, it could be cost, insurance and freight. It could be cost, insurance and freight plus 10% extra. So this is the basis of valuation. Subject to the provision of this act and in the absence of fraud, the value fixed by the policy is as between the insurer and the assured, conclusive of the insured value of the subject intended to be insured, whether loss be total or partial. So when you have concluded the contract, when you have agreed to a particular basis of valuation, you can not subsequently deviate from this basis of valuation. You can not open the value. When I say open the value, that means you cannot pay any amount lesser than the amount arrived at by the basis of valuation. So you have so if you have agreed to the basis of valuation of CIF plus 10% in the marine insurance policy. So if at the time of claim, you cannot say that I am going to pay only CIF value and not the additional 10%, because you have no documentary evidence in support of that extra 10% expenses or any such loss you have incurred. Once you have agreed to this basis of valuation of CIF and CIF plus 10%, you must pay the claim accordingly. You must have to pay that 10% extra at the time of loss. Whatever be the loss, whether the loss is total or the loss is partial. Unless the policy otherwise provides, the value fixed by the policy is not conclusive for the purpose of determining whether there has been a constructive total loss or not. So the concept of constructive total loss, we'll look at this principle subsequently. Measure of insurable value. Subject to any express provision or valuation in the policy, the insurable value of the subject matter insured must be ascertained as follows. In the insurance on goods or merchandise, the insurable value is prime cost of property insured plus expenses of and incidental to shipping and the charges of insurance upon the whole. It is more or less identical to CIF value. C means cost, the prime cost of the property insured, that is C, plus expenses of or incidental to shipping. Now freight is an expense which is incidental to shipping. So that is freight and the charges of insurance upon the whole. So usually we insure a goods on CIF for its CIF value, unless there is any express provision or valuation in the policy. So if there is any other form of valuation other than CIF in any insurance policy, then in that case, that basis of valuation supersedes this particular provision. However, if there is any insurance policy in which you have not agreed for any particular basis of valuation, in absence of any particular basis of valuation, the provision of this particular section will apply. That the value of goods will be considered as prime cost of property insured plus freight, that is expense or expense incidental to shipping, and charges of insurance policies. Section 30 says unvalued policies. And unvalued policies. An unvalued policy is a policy which does not specify the value of the subject matter insured, but subsequently, subject to limit of the sum insured, leaves the insurable value to be subsequently ascertained in the manner herein before explained. Following policies are usually unvalued policies. For example, increased value insurance policies, duty insurance policy. So if someone has obtained increased value insurance policy, now we all know that the increased value insurance policy is affected on commodities or cargoes which are susceptible to rapid fluctuation in their value. For example, crude oil. So you have effected an increased value insurance policy on crude oil. You do not know what will be the fluctuation in the prices or rates of crude oil, depending on geopolitical scenario of countries involved in the particular transaction. Now, you have fixed a sum insured in such increased value insurance policy. For example, 10 lakhs rupees. The basic CIF value is 10 crore. You have obtained increased value insurance policy on that basic cargo policy of 10 lakhs rupees. So the basic value is 1 crore. The increased value is 10 lakhs rupees. So subsequently, at the time of loss, the actual inflation or the actual increased value in the crude oil is, say, suppose 6 lakhs rupees. So the liability of the insurance company will be limited to actual increase or actual fluctuation in the value of commodity insured at the time of loss only. It is not considered as valued policy. The liability of the insurance is actual loss, loss at the time of loss, subject to maximum of sum insured fixed in the policy. So the value of the insurable value of the cargo damaged will be ascertained subsequently. Principle of contribution. Section 34, double insurance. So how the principle of contribution applies in the marine insurance policy, where two or more policies are effected by or on behalf of the assured on the same adventure and the interest or any part thereof, the sums insured exceeds the indemnity allowed by this act. The assured is said to be overinsured by double insurance. The assured is overinsured by double insurance. The assured, unless the policy otherwise provides, may claim payment from the insurer in such order as he may think fit, provided he is not entitled to receive any sum in excess of the indemnity allowed by this act. Where the assured receives any sum in excess of indemnity allowed by this act, he is deemed to hold such sum in trust for the insurers according to their right of contribution among themselves. This means, for example, in other line of property insurance, what happens is, if there is double insurance, for example, a policy, a property has been insured by 3 different insurance companies, and the coverage is identical in all these 3 policies, terms, conditions, warranties, all these things are identical in all these 3 insurance policies. What happens is, at the time of loss, all 3 insurance company will only pay their proportion of loss. That's it. A will pay his proportion, B will pay his proportion, and C will pay his proportion in the ratio of sum insured covered in respective policies. Okay, this will be the case. However, there is a provision in marine insurance by the virtue of this section that the assured can claim payment from insurer in such order as he may think fit. That means if the insured wants to claim entire amount from insurance company A, he don't want to claim anything from insurance company B and C. He want to claim entire amount from insurer A, he can do so. But in that case, the insurance company A will obtain a subrogation letter from the insured and he will go for recovery from company B and C subsequently. Okay. Principle of abandonment. Now, this is again different from other line of business because we do not find this principle in other LOBs. Principle of abandonment. What is abandonment? Section 61. Effect of constructive total loss. Where there is a constructive total loss, the assured may either treat the loss as a partial loss or abandon the subject matter insured to the insurer and treat the loss as if it were an actual total loss. So, by virtue of this section, the abandonment is made mandatory in case if the insured wants to claim constructive total loss under a marine insurance policy. So insured has two options. Either he can treat a loss as a partial loss, or if he at all wants to treat a claim as an constructive total loss, he must abandon the cargo to the insurance company. Now, what is constructive total loss in marine insurance? That it is completely different from the idea of constructive total loss we have in motor insurance policy. In motor insurance policy, it is clearly defined then when the liability of the insurance company exceeds 75% of the IDV, it is considered as constructive total loss. That is not the case here. The definition of constructive total loss is completely different in marine insurance. In marine insurance, constructive total loss means when the expenses, when the total amount of all the expenses incurred in retrieving the goods, in repairing the goods, exceeds the value of the goods when retrieved, then in that case it is considered as constructive total loss. Again, all those expenses, the amount of total amount of all the expenses incurred in retrieving the goods, in repairing the goods, in reconditioning the goods, exceeds the value of goods when they are retrieved. In that case, it is considered as constructive total loss. So that means, for example, the touch screen of my smartphone has been damaged. So the expenses incurred for repairing my smartphone or to apply new touchscreen on my smartphone comes to rupees 8,000. The expenses of touchscreen comes to rupees 8,000. And after repairing the smartphone, the value of smartphone comes to rupees 6,000. So after incurring the expenses of rupees 8,000, I'll be able to sell that smartphone for rupees 6,000. So it is considered as constructive total loss. Okay, this is the idea of constructive total loss in marine insurance. Notice of abandonment, section 62.
Excuse me, sir.
Sorry?
Sir, there is no predefined percentage in marine. As you
Sorry?
told that in motor, there is a. So as you told that in motor, if the expenses or the value of the item is beyond 70% of the IDV, we consider it as a total loss. So in marine, there is nothing like any percentage.
No, there is
Only-
in marine there is no percentage. There is a definition. In marine insurance, there is no percentage. Yes, in marine hull insurance, there is a definition of constructive total loss in Institute Time Clauses Hull 1996. There is a definition of constructive total loss that the liability exceeds 80% of the insured value, then it will be considered as constructive total loss. But that is for one particular case, not in general. Okay. In general, there is a definition of constructive total loss, which I have just explained. Okay.
Okay. Okay. So
You
this
got the
80% is only for hull, sir.
not in all the cases of hull. In one particular clause, Institute Time Clause Hull 1996, if I'm not mistaken, it is that particular clause in which there is a definition that the liability of the insurance company exceeds 80%, 80% of the insured value, then it will be considered as a constructive total loss. Other than that particular case, there is no such percentage in marine insurance policy.
Okay, right, sir.
Okay, you got the definition of constructive total loss, correct?
Right, yeah. Because
Okay.
basically when the expenses rating is more than the sound value.
If the expenses incurred are more than the value of goods after incurring the expenses, it will be considered as the constructive total loss. Okay, you remember this example of phone, correct?
Yeah. But, yeah.
Okay, the expenses incurred are 8,000 rupees, and after replacing the screen, we can sell the phone for rupees 6,000. So there is no commercial, benefit in this entire transaction. Will still be at the loss of rupees 2,000. So there is no, we should not go for repairing, and we should treat it as a constructive total loss. Okay. Okay. Any other doubts?
No, sir.
Okay. So notice of abandonment. Subject to provision of this section, where the assured elects to abandon the subject matter insured to the insurer, he must give notice of abandonment. If he fails to do so, the loss can only be treated as partial loss. Again, if the insured wants to claim constructive total loss in a marine insurance policy, the abandonment is must. Notice of abandonment may be given in writing or by word of mouth, or partly in writing or partly by word of mouth. The notice of abandonment is properly given. The rights of the assured are not prejudiced by the fact that the insurer refused to accept the abandonment. The mere silence of the insurer after notice is not acceptance. Where notice of abandonment is accepted by the abandonment is irrevocable, the acceptance of notice conclusively admits liability of the loss and sufficiency of the notice. Notice of abandonment may be waived by the insurer. Now, this section is of utmost importance from the perspective of the insurance company. In practice, we do not even acknowledge the receipt of notice of abandonment. Always remember, if the insured wants to claim constructive total loss under a marine insurance policy, if he wants to claim constructive total loss, if he serves a notice of abandonment to the insurance company, do not even acknowledge the receipt of notice of abandonment. Do not even acknowledge the receipt, let alone acceptance of abandonment. Okay, first and foremost. Second thing, once you accept the abandonment, the acceptance is irrevocable. That means you have accepted the liability. When you accept the abandonment of goods, you have accepted the liability under the insurance policy. That means subsequently, after appointment of a surveyor, subsequently if any fact or if any representation comes to your notice, which can prejudice the claim, which can affect your liability, you cannot invoke that fact. You cannot invoke any particular terms, conditions, or warranty of the insurance policy. It is as simple as that. Once you accept the abandonment, you have admitted the liability. Now you have to pay the total loss. Okay. Now, what is the difference between principle of subrogation and principle of abandonment? This is very important. This comparison is extremely important. how principle of abandonment is different from principle of subrogation. All the rights and remedies of the insured against any negligent third party is transferred to the insurer under the principle of subrogation. So under the principle of subrogation, only the rights and remedies against any negligent third party is transferred to the insurance company. On the contrary, the title of the goods passes to the insurer. That means the insurer literally becomes the owner of the goods. The entire title of the goods passes to the insurer, not only rights and remedies of the insured. Second point, the insurer can recover from the negligent third party only up to the amount of claim paid by the insured. Any amount recovered in the excess of the claim amount paid must be transferred to the insured. So if the insurance company has paid claim of rupees 1 lakh and so if the insurance company has paid the claim of rupees 1 lakh and he has recovered rupees 1,20,000 from negligent third party by virtue of right of subrogation. He has recovered rupees 1,20,000. Now he has recovered rupees 20,000 more than the claim amount paid to the insured. He has to give or he has to transfer that extra 20,000 rupees to the insured. He cannot keep that extra 20,000 rupees with himself. The insurance company cannot do so because the title of the goods has not transferred from the insured to the insurance company. The insured is still the owner of the goods. He still holds the title of the goods. However, in the principle of abandonment, since the insurance company has become the owner of goods, the title has transferred to the insurance company. He can recover any amount in excess of the claim amount paid. He can recover any amount because now the insurance company is owner of the goods. So if the insurance company has paid rupees 1 lakh to the insured for the claim and he is able to recover rupees 1,20,000 from the negligent third party, he can keep that entire amount with himself. Only rights and remedies of the insured against any liability is transferred to the insurer, not any liability attached therewith. However, to the contrary, since the insurer becomes the owner of the goods, all the liabilities associated with the goods are also transferred to the insurer. Therefore, in practice, notice of abandonment is not accepted by the insurer unless all the relevant information pertaining to the goods are available to the insurer. In general, insurer does not even acknowledge the receipt of notice of abandonment. So what happens is, if you accept the abandonment, not only rights and remedies, because since you have become the owner of the goods, all the liabilities associated with that particular good also transferred to the insurance company. So what kind of liability? For example, damage. If the goods are lying at the port premises since long time, the port will charge damage on goods if they are lying at the port premises after the permissible time period. For example, if the port allows you to keep your goods at the port premises for say 1 month or 7 days, after that point of time, if you have not taken the delivery of the goods, they will charge you demurrage. They will charge you late penalty or late fees in delaying for delay in taking the delivery of the goods. So that liability will also come to the insurance company if the insurance company has accept the abandonment. So in practice, what we do, when we receive the notice of abandonment, we will not acknowledge it. Then we will depute our surveyor. He will go to the port premises, or he will go to the location where the goods are lying. He'll inquire about all the facts and circumstances related to the goods. Then he will give his report that this will be the amount we can recover by disposing of the goods, and these are the liabilities, these are the associated liabilities. And this is the amount of total loss. After comparing all these things, we will come to the decision whether we are going to accept the amendment or not, and whether we are going to treat this claim as constructive total loss or partial loss. Principle of proximate cause, we will not look at this principle because there is literally no change in this principle. It is same as the other line of business. Any doubts as far as the principle of marine insurance are concerned?
Doubt is only regarding this assignment.
Sorry.
So you say that the assignment are freely, I mean the assignments are free in marine.
Marine policies
So,
are freely assignable. Okay.
Yeah, but somewhere it is said it is done by endorsement and somewhere it is automatic. So, sir, can you please elaborate with the help of an example?
Look, the marine policies are freely assignable, but the assignment is not automatic. That means there has to be some sort of agreement between the seller and the buyer. Between the assigner and the assignee, there has to be some sort of agreement. Okay, so that means suppose you are seller and I'm buyer. Okay, and the term of our sale, the contract of our sale is based on CIF Incoterms, that is cost, insurance, and freight. Okay, now there is explicit obligation on the seller. You are the seller. By virtue of CIF Incoterms, there is an obligation on you that you will arrange insurance on the goods on behalf of me. For my benefit, you will arrange insurance at least up to port of discharge. Okay, now the point of delivery is identical in C&F, FOB, and CIF. In all these three Incoterms, the point of delivery is identical. That is, the risk transfer point is identical. That is FOB, free on board point. What is free on board point? When the goods passes the ship's rails and placed safely on board the vessel. That is the free on board point. So it is identical in all these three Incoterms. Okay, what is the difference? The difference is there is no obligation of arranging insurance on the seller in first two Incoterms, that is C&F and FOB. There is no such obligation. However, there is such obligation of arranging insurance on behalf of buyer. In CIF, there is such obligation. So in first two Incoterms, FOB and C&F, the assignment is not automatic. You have to actually assign the policy in favor of buyer. However, in CIF, the assignment is automatic. Even after FOB point, you as a seller, you have lost insurable interest after FOB point. And as a buyer, I have gained insurable interest in the goods. But in CIF, since there is an agreement, there is explicit agreement that you will arrange insurance on behalf of me, the assignment will be automatic. And there is no such agreement in FOB and C&F contract. So you have to explicitly assign the policy in my name before you lost your insurable interest. Before FOB point, you have to assign the policy in my name. If you have not assigned the policy before FOB point, the assignment is not automatic and the policy will not be considered as assigned in my name after FOB point. Is it clear?
Yes, it means that if I have taken CFR, I'm on caution free. So
Okay.
once the item is loaded on the ship, I mean, it passes the ship's rail. So if I want to assign the policy to the buyer, so I have to give an endorsement.
Okay.
In case of CIF, they don't need to give any endorsement.
Yes, in case of CIF, there is no need for any explicit assignment. It is considered as automatic. Look, there is one section. Wait. Now, look at this section. Section 70 says, unless, that means there is an exception. What this exception says? What are the circumstances under which there is no need for any express assignment unless there is an express or implied agreement between the assignee to that effect? There is already an express agreement or implied agreement between the seller and buyer to that effect. What is that agreement? CIF obligation. What is CIF obligation? That the seller will arrange insurance on behalf of buyer at least up to the port of discharge. There is an obligation, there is an agreement. So there is no need for any express assignment. Got it?
Okay, sir. One more doubt, sir. Suppose the ship is on the voyage and suppose you're going to Cape Town and
Wait.
something happened in Cape Town and it becomes a port of distress.
Can you repeat,
So
please? Can
if
you
the
repeat
seller
your
is
question,
taking
please?
CFR,
Sorry, I didn't hear it. Can you repeat your question, please?
yes, sir. Suppose I have taken the CFR
Okay.
and the ship is on the voyage to Cape Town. And I mean the destination port is Cape Town.
Okay.
So something happens in Cape Town and the ship has been diverted from the main route. So who will inform, sir, to the insurance company, the seller or the buyer will inform in case of CFR? I'm not sure basically
In case
it
of
is still on the
CFR, if there
seller.
is
Should he inform, sir, should the seller inform or the buyer should inform?
in case of CFR, you said that the goods are sent from India to Cape Town on CFR basis, right?
Yes, sir. Yes, sir.
And the loss were discovered or loss has occurred in Cape Town, right?
Not lost, sir. I mean, the Cape Town has become a port of distress. The ship has to change its course
Okay.
to somewhere else.
Okay.
So in that time, who will inform to the insurer, the seller or the buyer? If it is a
Look,
CFR.
it is as simple as that. A person who has insurable interest at the time of loss will inform the insurance company. It is as simple as that. Okay. So if the goods are sent on CFR and if the seller has assigned the policy before FOB point in favor of buyer, and if the loss was discovered or loss has occurred at Cape Town, obviously the buyer will inform the insurance company, because after FOB point, the buyer has insurable interest and the seller's insurable interest has already been terminated. Okay.
Okay.
Okay. Any other doubt?
Yes, sir. This is understood
Yes.
that basically we can really say that it has the implied warranty that the ship has to be seaworthy. This is understood. But so other thing that
Pardon?
regarding this that implied warranty that the ship has to be seaworthy, that is understood.
Okay.
But one more thing is that you said that the cargo need not to be seaworthy.
Okay.
So how do you decide cargo is not seaworthy? It is already
Exactly.
packed. How do you
That's why there is no such implied warranty, because you cannot say that the cargo is seaworthy or not. Because there is no such thing as goods or cargo being seaworthy. Nothing can be no goods can be seaworthy. Is there any goods you will throw the goods in sea and it will still survive? There is no such goods as I mean, so there is no such thing as goods or cargo being seaworthy. So that's why there is no such implied warranty of goods or cargo being seaworthy. Okay.
Right.
Okay. Okay. So should we take a break of 10 minutes and we will resume on 1:30? Okay.
Yeah.
Okay. Okay. Thank you.
Thank you.
Good afternoon, everyone. Sorry for the delay. Should we resume? Is it visible to everyone?
Yes, sir.
Okay. Am I audible?
Yes, sir. Audible.
Okay.
આવું ના કરાય કોઈને પેલા માટે સેવા આપવા માટે તો મેં છોકરીને પેલી કરી નાખશું અરે સમજી છે તમે લાગી
Hello. Am I audible?
Yes, sir.
Okay. So now we will look at the various coverages available in marine cargo insurance. Marine cargo insurance being international in nature, to bring uniformity in coverages offered worldwide, Institute of London Underwriter introduced first set of cargo clauses, that is Institute Cargo Clauses A, B, and C, 1982. So we all know that the marine cargo insurance is international in nature. Multiple countries are involved in a particular trade or transaction. The rules governing insurance policies, coverage is available under various insurance policies. Their terms, conditions, their warranties are different in various countries. So it is not possible to transact the insurance business over multiple countries unless there is uniformity in coverages, unless there is the coverages are identical for all the countries involved, because there will be disputes, there will be issues regarding at the time of loss, at the time of claim. So to bring that uniformity in the coverages worldwide, ILU, that is Institute of London Underwriters, introduced the first set of cargo clauses. These are Institute Cargo Clauses A, B, and C. Now these cargo clauses A, B, and C are general in nature. I mean, the ABC, I mean, they are applicable for general nature of cargo. For example, we have, for example, textile goods, for example, papers, any other general goods of cargo. So they are very much relevant. They are suitable for general cargo. Of course, we have many trade clauses. We have many commodity clauses like Institute Coal clauses, Institute Bulk Oil clauses, Institute Timber Federation clauses, Institute Jute clauses, Natural Rubber clauses, Frozen Food clauses, Frozen Meat clauses. Now these are very specific clauses. They serves the requirement of a particular commodity. They serve the requirement of a particular nature of cargo. But for general cargo, we have these three clauses, ICC A, B, and C. They are called institute clauses because they were formed by Institute of London Underwriters. That's why they are called institute clauses. So ICC A, B, and C. ICC B and C being named peril clauses and ICC A being all risk cover. What is named peril cover? So only the perils named or enumerated in the policy are covered, subject to, of course, subject to other exceptions and terms and conditions of the policy. That is named peril policy. All risk cover. That means anything which is not excluded in the policy schedule is deemed covered. And if there is a loss, and if the loss does not falls under any of the exception mentioned in the policy, it is covered. Apart from this, what is other salient feature of a named peril policy and all risk policy? If someone can explain what is the biggest difference between the named peril policy and all risk policy?
So in all risk, there will be exclusions mentioned. And the name
that we have
in the
already
name
discussed. That we have already discussed. Sorry. Apart from that, what is the biggest difference? The biggest difference is of onus. Onus of proof. Okay, that is the biggest difference. In a named peril policy, the onus is on the insured that the loss has occurred due to one of the named perils. Again, in a named peril policy, the onus is on the insured that he has to prove that the loss has occurred due to one of the named perils. However, as far as all risk policies are concerned, there is no such onus on this insured. If the insured can confirm that the loss does not fall under any of the excluded perils, it is sufficient to pay the claim. There is no onus on the insured to prove that the loss has occurred due to so and so peril. There is no such onus on the insured that he has to prove that the loss has occurred due to this peril, this particular peril. No. If the insured can prove that, look, there are 10 exceptions in the policy, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. These are the 10 exceptions under the policy. Okay. And if the loss does not fall under any of the excluded peril, then there is the claim is payable and there is no other onus on the insurer. These are draft clauses. They are the insurers are free to make any changes in these clauses as per the requirements. So one should remember that these are not law or regulations or rules. These ICC clauses are not any regulation rules. These are only draft specimen. When I say draft specimen, that means you can make n number of changes in any clause. For example, ICCB clause. So ICCB clause does not cover rainwater damage. ICCB clause does not cover freshwater damage. It only covers entry of sea, river, or lake water in container hold or in a vessel hold or in a place of storage. It only covers that peril: sea, entry of sea water, lake water, and river water. But if you want to add rainwater and freshwater damage as well, apart from these by default covered perils, you are free to do so. So these are draft clauses. One must remember that these are draft clauses. The insurer are free to make n number of changes they want in these clauses. These clauses are also not legally enforceable. Okay. So if you are giving ICC a clause, which is all risk in nature, and if you want to incorporate further 5 more exclusion, that I want to exclude all these perils apart from those perils which are excluded by default, I want to exclude these further more perils, you are free to do so. These clauses are more relevant for the cargo of general nature. We have already discussed that. Subsequently, various commodities clause to suit the requirements of particular commodity were also introduced by ILU. For example, institute coal clauses, because the institute coal clauses covers spontaneous combustion. Now, as far as coal is concerned, during transit, when the coal transit from various tropical zone, various countries in which there is variation of temperature, variation of atmosphere, moisture content, it is susceptible to spontaneous combustion, because this is the biggest hazard associated with a coal, spontaneous combustion. Now, in ICC A, B, and C, we have general exclusion number 4.4. Now, that general exception 4.4 says loss or damage caused by inherent vice or nature of subject matter insured. So, inherent vice or nature of subject matter insured means spontaneous combustion is an inherent vice for coal. There is no external peril or external agent or external factor that has contributed in the loss. Spontaneous combustion is inherent vice. So if you are giving ICC-A or ICC-B cover to coal, it is not sufficient to cover the coal, or I mean, it will not cater the requirement of an insured. So we have instituted coal clauses, then we have instituted bulk oil clauses, frozen food clauses, jute clause, nature rubber clause, etc. Later in 1998, ILU merged with LIRMA, that is London International Insurance and Reinsurance Market Association. And now the governing body is International Underwriting Association, IUA. Now, the second set of these clauses, Institute Cargo Clauses A, B, and C. So the second set was introduced in 2009, which is till date, it is very relevant and it is prevalent. As on today, we have more than 480 clauses drafted by IUA for marine insurance LOB. Now we look at these clauses one by one. These are, we are not going to discuss versions of 1982, okay, because the versions are redundant and no one used those sets of clauses. So we will look at the versions of 2009, 1st January 2009, ICC A, B, and C. So each of these three clauses contains 19 clauses in total in this particular order. First clause is risk covered. Second clause is general average. Third clause is boat to blame collision clause. Fourth clause is general exclusion, unseaworthiness, unfitness exclusion. Then war exclusion, strike exclusion. Eighth is duration clause, transit clause, termination of contract of carriage, change of voyage. Then we have 4 clauses related to claims, insurable interest, forwarding charges, constructive total loss, increased value insurance, and so on. We have total 19 clauses. And we will look at some of the most important clauses from which you will get questions in examination. The first and foremost is risk covered clause. So we'll first look at the ICCC risk covered clause. This insurance covers except as excluded by provision of clauses 4, 5, 6 below. That means these are the named perils which are also subject to clause 4, 5, 6, and 7. That doesn't mean that the peril covered is fire, then fire is covered outrightly. The peril of fire is also subject to excluded clauses in 4, 5, 6, and 7. So as we have already discussed, the fire, if the fire is caused by spontaneous combustion, it is not covered. Because spontaneous combustion being inherent vice in nature, it is excluded by virtue of general exclusion 4.4. So these named perils are also covered subject to these excluded clauses 4, 5, 6, and 7. Okay. So loss of a damage to subject matter insured reasonably attributable to fire or explosion, vessel or craft being stranded, grounded, sunk, or capsized, overturning or derailment of land conveyance, collision or contact of vessel or craft or conveyance with any external object other than water, discharge of cargo at a port of distress. Now, why I have underline these phrase, we'll look at this the importance of this phrase. The loss or damage to the subject matter insured reasonably attributable to fire or explosion. So suppose your goods are covered for ICCC perils or ICCC clauses. Okay, your goods are on board the vessel. There is a fire in the adjoining goods. There is a fire in the adjoining goods. Now the crew of the ship started firefighting operation, and they have extinguished the fire in the adjoining goods, the goods lying next to your goods. They have started firefighting operation. They have started spraying water in that goods, and the fire was extinguished. Now in that firefighting operation, due to that water, your goods are also damaged or destroyed. Whether the claim is payable or not. If anyone of you can answer whether the claim is payable or not. Your goods are damaged due to water sprayed in extinguishing the fire, which was originated in the adjoining goods. Is the claim payable?
The goods which were extinguished, it was insured with the fire policy.
No, it
Then
was not.
our
It was
part
not.
would be-
It does not belong to insurance. I'm repeating the example. Your goods are lying on board the vessel. Okay, there is a fire in the adjoining goods which does not belong to you. Okay, the fire is in the adjoining goods which does not belong to you. Now the crew member started firefighting operation by spraying water to extinguish the fire. The fire was extinguished. There is no fire in your goods. There is no fire in your goods, but your goods were damaged due to that water used in firefighting operation. Whether the claim is payable under ICCC or not.
It's not payable.
It is payable.
Oh.
It is payable because it is reasonably attributable to fire. Correct? It is reasonably attributable to fire. In absence of fire, whether the water would have arrived there.
No, sir.
Correct?
Right.
In absence of fire, there was no need of spraying water there. Okay. So the water was sprayed due to fire. So obviously the goods were not damaged directly due to fire. But yes, the goods were damaged reasonably attributable to fire. So that's why this phrase is of utmost importance. Okay. Vessel or craft being stranded, grounded, sunk, or capsized. It is also covered. Overturning or derailment of land conveyance. It is also covered. Collision or contact of vessel, craft, or conveyance with any external object other than water. Other than water, when we say other than water, it also includes ice. Okay. So collision with iceberg is also not covered under ICCC. But collision or contact of vessel, craft, or conveyance with any other external object is other than water is covered. Again, I'll ask you another question. There is collision of vessel with any other object which is not water or ice. There is a collision of water of vessel with any other object. There is a hole in the hull, or you can say the body of the vessel. There is a hole. Through that hole, the seawater comes to the hold of the vessel and the goods are damaged. I'm repeating the example. There is a collision with any external object and there is a hole in the hull or machinery, hull or the body of the vessel. And through that hole, the seawater comes to the hold or the storage area of the vessel and the goods are damaged. Whether the claim is payable under ICCC or not.
It may not be payable.
Why it is not payable?
Because it is not correlated with the ship. It is correlated with some other object.
But that's what it is mentioned here, that the collision with any other external object other than water is covered. It is not necessary that the vessel has to collide with any other vessel or ship. It can collide with jetty, it can collide with crane, it can collide with any other port equipment. Everything is covered. The question is whether the entry of seawater is covered under ICCC or not. So if
Seawater is
you,
covered.
huh?
Yes, ingress of seawater is covered.
No, under ICCC, entry of seawater is not covered. However, for the particular example, for the particular example I have given you, the claim is payable because it is reasonably attributable to collision. Okay, so if it is if there is entry of seawater without any collision, and if the entry of seawater damages the goods stored in the ship, it is not covered in ICCC. However, if there is a collision and there is a hole in the hull of the vessel, and through that hole, seawater enters into the storage area and it damages the goods, it is covered. It is very much covered under ICCC because the entry of seawater can be reasonably attributable to collision. It is clear?
Yes, sir. Yes, sir. It's clear.
Okay. I have given you these two examples just to make you understand importance of this phrase, reasonably attributable to. That's it. Fifth is discharge of cargo at a port of distress. Now we will look at this peril subsequently. After we understand the clause 13, forwarding charges clause, we will look at this peril subsequently. Loss of or damage to the subject matter insured caused by general average sacrifice, jettison. Okay, general average sacrifice and jettison. Now, what is general average? This is the definition of general average. It's an ancient principle of equity recognized by maritime nations, predating the concept of insurance and still valid today. Now, what is general average? So, in which all the parties involved in the sea adventure, vessel, cargo, and freight, proportionately shares loss from the voluntary and successful effort to save the entire adventure from an imminent peril. There are two types of general average acts: general average sacrifice and general average contribution. Now, what is general average? So, it's a sacrifice or expenditure incurred which is of extraordinary nature first. It is incurred voluntarily, it is of extraordinary nature, and it was incurred to safeguard the entire adventure, entire maritime adventure from an imminent peril. And the act of general average must resulted into a successful venture, in a successful adventure. Then and then only it can be considered as an act of general average. Is it clear? First, the expenses, the sacrifice or expense incurred, it should be voluntary, it should be extraordinary in nature, and third, it was required to safeguard the entire adventure. Okay, so for example, there is fire in one goods, and there are explosives which were stored near to that particular goods. Now, if you are unable to control that fire, you are trying your best. The crew members are spraying water, they are using fire extinguishers, they are unable to control the fire. Now you are under a threat that if that explosives which are lying nearby the fire affected goods, if those explosives catch the fire, the entire adventure would be lost. There will be a huge explosion on the vessel and the entire adventure will be lost. So you throw that explosive into the water to safeguard the entire adventure. This will be termed as a general average. Okay. Now that act of throwing overboard the vessel of the goods or cargo is considered as act of jettison. Now this is the definition of jettison: deliberate or voluntary throwing overboard of cargo or of ship's superstructure, equipment, or stores, or to protect other property from a common peril. Cargo or vessel's property can be jettisoned to lighten the vessel, to stabilize it during a storm, or to get rid of flammables or explosive during fire. So that act of throwing overboard a vessel of goods or cargo or any property of the vessel is considered as jettison. So there are two types of act of general average sacrifice and general average contribution. What is the difference between general average sacrifice and contribution? Sacrifice or jettisoning of cargo property of a vessel is called general average sacrifice. When your own goods are jettisoned, when your own goods are sacrificed in an act of general average, it is considered as general average sacrifice. But when your goods are not, your goods are safe, your goods are not sacrificed or jettisoned in an act of general average, but you are contributing towards someone else's loss, that is called general average contribution. So your goods are safe, but someone else's goods are jettisoned on board the vessels, and now you as a part of cargo owner contributing towards his loss, it is considered as general average contribution. Okay, so general average sacrifice is also covered under ICC, and jettisoning is also covered under ICC. Now this is an example. There are 10 interests on a vessel, including vessel owner and charterer. So say one is the shipping line or charterer or the owner of the vessel, and there are 9 cargo owner from A to J. Okay. Now cargo of A worth rupees 10 lakhs was jettisoned to safeguard the common adventure from the maritime peril. Now this extraordinary sacrifice of rupees 10 lakh will be apportioned on all the 10 parties or interest, including A, whose cargo was jettisoned. So the extraordinary sacrifice of 10 lakhs will be apportioned on all the 10 interests, including the person whose cargo was sacrificed. Okay, because if he is not involved in this act of general average, you will be placing him in a better place other than all the parties whose cargo was saved in the act of general average. Okay, because he will receive entire 10 lakhs rupees from the remaining 9%, and the remaining 9% will lose more than 1 lakh rupees whose cargo is saved. So this rupees, the sacrifice of rupees 10 lakhs will be apportioned on all the 10 parties, including the person himself. Now remaining 9 parties will make contribution to A of rupees 1 lakh. So the A will also be a rupees 1 lakh. For A, it's a general average sacrifice, and he can claim the remaining 1 lakh rupees because the total value of cargo which was jettisoned was rupees 10 lakhs rupees. Now A has already received rupees 9 lakh rupees from other parties. Okay, he has been already compensated to the extent of rupees 9 lakhs from the other parties. So the remaining 1 lakh rupees he can claim from the insurance company under general average sacrifice. A can contribute, he can claim the remaining 1 lakh rupees from his insurance company. Now, the remaining 9 parties who has contributed to the loss of A, rupees towards general average contribution under clause 2 of general average. Is this example clear?
Clear, sir.
The concept of general average is clear or not?
Clear, sir.
Okay. Now we look at the perils covered under ICC B. So the additional perils covered under ICC C, I mean 1.1.1 to 1.5, they are identical to C perils. The additional peril which is covered under 1.6 is earthquake, volcanic eruption, or lightning. It is also covered under ICC B perils. Okay. Then we have general average sacrifice is also covered. Jettison or washing overboard is also covered. Entry of sea, lake, or river water into vessel, craft, hold, conveyance, container or place of storage. It is only covered. Only entry of sea, lake and river water is covered. Fresh water and rainwater damage is not covered under ICCB peril. Okay. Fresh water and rainwater damage are not covered under ICCB peril. Then total loss of any package lost overboard or dropped whilst loading onto or unloading from vessel or craft. This is called sling loss. Sling loss, I mean, in a slang language, it is called, or in a maritime language, it is called sling loss. Sling loss means total loss of any package lost overboard or dropped whilst loading onto or unloading from vessel or craft. So there are two aspects to this peril. One, there has to be total loss of entire package. Partial loss is not covered. Total loss of entire package. Second, whilst loading onto or unloading from vessel or craft, that is only covered. So if there is a total loss of any entire package whilst loading onto or unloading from a land conveyance, whether it is covered or not, no, it is not covered. During land conveyance, it is not covered. There has to be total loss and it is covered whilst it is loading into or unloading from a vessel or craft. ICCA, we all know that it is an all risk peril, other than those excluded perils in clause 4, 5, 6 and 7. Clause 4 is a general exclusion, clause 5 is unseaworthiness exclusion, clause 6 is war exclusion, clause 7 is strike exclusion. So other than those exclusion, everything is covered under ICCA perils. Any doubts regarding any of the insured perils? Okay.
No, sir.
Okay. Now the clause 2 is general average clause. Clause 2 is general average clause. So the clause 2 says the insurance cover, this insurance covers general average and salvage charges adjusted or determined according to the contract of carriage and or governing law practice incurred to avoid or in connection with avoidance of loss from any cause except those excluded in clause 4, 5, 6 and 7 below. So what does this particular clause cover? Again, when we will look at this example. So suppose you are party B. Okay. Now in this example, your cargo or your goods are not damaged or destroyed, but you are still contributing towards loss of A. So you have also made a contribution of rupees 1 lakh to compensate the party A. So of course your goods are intact. There is no loss or damage to your goods, but you can still claim that amount of rupees 1 lakh which you have contributed towards party A from your insurance company. Is it clear? So this clause 2, general average and salvage charges clause, this covers the scenario when your goods are not lost or destroyed, but you are still contributing towards someone else's loss in an act of general average. So you can claim that general average contribution from your insurance company. Section 66 of general average, section 66 of Marine Insurance Act defines the general average loss. What is the definition of general average? A general average loss is a loss occurred by or directly consequential on a general average act. It includes general average expenditure as well as general average sacrifice. There is a general average act where any extraordinary sacrifice or expenditure is voluntarily and reasonably made or incurred in time of peril for the purpose of preserving the property imperiled in the common adventure. We have already discussed that definition. Now, where there is a general average loss, the party on whom it falls is entitled, subject to the condition imposed by maritime law, to a rateable proportion from other parties interested, and such contribution is called general average contribution. So in the earlier example, we have seen that the party A was entitled to receive contribution of rupees 1 lakh from the remaining 9 parties in the maritime adventure. So this is the governing principle or governing provision of the Marine Insurance Act. Subject to any express provision in the policy where the assured has incurred a general average or expenditure, he may recover from the insurer in the respect of the proportion of loss which falls upon him. And in case of general average sacrifice, he may recover from the insurer in respect of whole loss without having enforced his right of contribution from the other parties liable to contribute. So both the options are given to the insured, of course, subject to any express provision in the policy. So we have seen that the remaining 9 party will contribute rupees 1 lakh to party A. So against loss of rupees 10 lakhs, he has already received rupees 9 lakh from the remaining parties. So that loss of rupees 1 lakh, the party A can easily claim from his insurance company by virtue of this provision. Subject to any express provision in the policy where the assured has paid or liable to pay a general average contribution in respect of interest insured, he may recover therefrom from the insurer against. This is the provision of general average contribution. So in a scenario when your goods are not lost or destroyed, but you are still contributing towards some other person's loss or damage, you can claim that contribution from your insurance company. So other than party A, from party B to J, the remaining 9 parties who have paid rupees 1 lakh to party A, they can claim rupees 1 lakh from their respective insurance company by virtue of this provision. In the absence of express stipulation, the insurer is not liable for any general average loss or contribution where the loss was not incurred for the purpose of avoiding or in connection with the avoidance of a peril insured against. So this is one of the important provisions which says that the peril to avoid a peril in avoidance of which an act of general average was performed must be an insured peril. Okay. If you have performed the act of general average to avoid a peril which is an excluded peril, then the insurance company is not liable to pay the claim. Where ship, freight, and cargo or any two of those interests are owned by the same assured, the liability of the insurer in respect of general average losses or contribution is to be determined as if those interests were owned by different persons. Hello? Salvage charges. Now, what is salvage charges? Subject to express provision in the policy, salvage charges incurred in preventing loss by insured against may be recovered as a loss by those perils. Salvage charges mean the charges recoverable under maritime law by a salver independently of contract. They do not include expense of services in the nature of salvage rendered by the assured or his agent or any person employed for hire by them. The purpose of averting a peril insured, such expenses were properly incurred may be recovered as particular charges or as a general average loss according to the circumstances under which they were incurred. So these two terms, salvage charges and general average, are more or less, more or less they are same. They are identical. The purpose for which they are incurred are also identical. In both the scenarios, the expenses or the sacrifice must be extraordinary in nature, must be incurred voluntarily, and must be incurred to avoid the entire maritime adventure from becoming a total loss. So the properties of both these expenses or charges, salvage charges as well as general average, they are identical, and they are also used interchangeably. So that if you look at this clause, general average and salvage charges, the term used is general average and salvage charges. Now this is one of the example. In, I guess, March or April 2021, this was the ship Ever Given. The name of the ship was Ever Given, and it is owned by a shipping line, Evergreen. Okay, so the Evergreen is the shipping line, and the name of the vessel is Ever Given. So the vessel was stranded in the Egypt Suez Canal. Now this is one of the most important Suez Canal of entire world as far as the Middle East business transaction is concerned. So the ship was stranded something like this, and it blocked the entire Suez Canal. So this was the entire Suez Canal. You can see these vessels being halted due to the entire Suez Canal being blocked by this vessel. Okay, so these are the someone's mic is okay. So these were the salvage operations conducted by the shipping line to safeguard the entire operation, because this was a scenario where the entire ship was stranded, and hence the entire adventure was at imminent peril, because this was a container ship. You can see all these containers. So this is a dredging operation. This is a dredging operation. Sorry for the interruption. So these are the salvage operation. Here you can see the dredging operation. Dredging operation means they are deepening the depth of the Suez Canal by dredging the shore or bank of the canal, so that the vessel can be refloated. Okay, so these are the dredging operations. Now this is called tugging operations. So these are the tugs. So tugs are very high brake bulk, brake power and high powered engine vessels. They are exclusively used only for the salvage operations. They are not used for transportation of goods or passengers. They are exclusively used for these salvage operations. So you can see that they are deepening the depth of the canal here by dredging operation, and these are the tugs. Total, I guess, 14 tugs were used. 14 tugs were used to refloat the vessel. So they are pulling the vessel from this side. These tugs are pulling the vessel from this side to refloat the vessel, and here you can see the dredging operations. So this is called salvage operations. So what will happen for the time being, when the salvage operation were going on, the shipping line, the owner of the vessel or the owner of the ship will bear the all the expenses, salvage operations expenses. But subsequently, he will apportion all the salvage expenses on the cargo owners as well. He will also participate in this operation, salvage distribution operation, and he will also apportion the expenses on the cargo owners. So now you can see that none of the goods are damaged in this operation, but you have still incurred many expenses, salvage expenses. So all these cargo owners can claim that salvage expenses which they have contributed to the shipping line. They can claim that salvage expenses from their respective insurance company by virtue of clause number 2. Okay. Boat to blame collision clause. Again, this is one of the mysterious clause of marine insurance. Boat to blame, BTBC, boat to blame collision clause. This insurance indemnifies the insured in the respect of any risk insured herein against liability incurred under boat to blame collision clause in the contract of carriage. In the event of any claim by the carrier under the said clause, assured agree to notify the insurer who shall have right at their own cost and expenses to defend the assured against such claim. So the doctrine of boat to blame collision clause is a American doctrine. It was more prevalent in United States of America. This clause features in bill of lading and charter party agreement. So if you look at the reverse side of any bill of lading, you will find this boat to blame collision clause. Okay. Now what does this clause say? So when two vessels collides due to the sole fault of one or both contributing to the collision in varying percentage of fault, and cargo in one or both the vessel are damaged or lost, clause in bill of lading will come into play. So this boat to blame collision clause will be triggered when there are when the two vessels collides with each other, and there is a scenario when you cannot put blame on one of the vessels, and if both the vessels are to be blamed, of course the nature of blame or percentage of fault will vary accordingly, and cargo on one or both the vessels are damaged, then in that case this clause will come into play. Okay. The owners of the damaged cargo may claim for the losses either from their cargo insurer, vessel's owner in which the cargo was carried, and the vessel owner of the other vessel who has contributed to the collision. By inserting the boat to blame collision clause, each of the vessel owner can recover from other losses for cargo in proportion of percentage of their fault or blame. This loss payable by each vessel owner is in turn recoverable from the cargo owners in the respective vessel in proportion of the value of their cargo before the collision. Now this is the example. Okay. There are two vessels, vessel A and vessel B. And cargo on vessel A, cargo owner on vessel A suffers loss of rupees 1 lakh due to collision between these two vessels, vessel A and vessel B. Okay. So the cargo owner has three options. He can either claim from his insurance company, he can claim from the vessel owner in which the cargo was lying, or he can claim from the vessel owner, the other vessel owners who was involved in the collision. So now here the cargo owner has claimed damages from vessel A, the vessel in which the cargo itself was lying. So the cargo owner has claimed damages from vessel A. Vessel A pays compensation to cargo owner of rupees 1 lakh. Now what vessel A will do? The vessel A will proceed against vessel B by provision of this boat to blame collision clause, and the liability was apportioned in 40% to 60%. 40% in favor of vessel A and 60% in favor of vessel B. That means fault of vessel A was only 40%. So he was liable to pay only rupees 40,000. And the fault of vessel B was 60%. So the vessel B is liable to contribute rupees 60,000. So therefore, vessel is eligible to claim rupees 60,000 from vessel B. So he has made a claim of rupees 60,000 against vessel B. Vessel B has honored the claim of vessel A of rupees 60,000. Now, under Carriage of Goods by Sea Act and under Bill of Lading Terms and Condition, under COXA and Bill of Lading Terms and Condition, vessel owner is not responsible for negligence in navigation or management of vessel. So what vessel B will do? The vessel B will apportion the claim of rupees 60,000 on her cargo owners under BTBC, Boat to Blame Collision Clause. So the vessel B will ask the cargo owners to compensate her for rupees 60,000 in the proportion of their respective values by virtue of this Boat to Blame Collision Clause of Bill of Lading. Before they take delivery, the vessel owner will not give delivery of the goods unless cargo owner contributes towards this BTBC clause. So now in this case, your goods are not damaged in the entire scene, but still you have to contribute by virtue of this BTBC clause. So that contribution, for example, there are 10 cargo owners and each of them has to contribute towards this BTBC clause, rupees 6,000 per head. So all 10 cargo owners have contributed rupees 6,000 per head to the vessel owner P. Now that amount of rupees 6,000 they can claim from their insurance company by virtue of this clause 3, Boat to Blame Collision Clause. I know this is very mysterious clause and it is difficult to understand, but I hope it is now clear with this example, Boat to Blame Collision Clause. Okay, is it clear? Okay. The clause 4 is general exclusion. There are 7 general exclusion in ICCC 4.1 to 4.7. And there are 8 general exclusion in ICC B and C 4.1 to 4.8. The additional general exclusion is of malicious damage. Now we'll look at all these exclusion one by one. 4.1 is simple. Loss of damage or expenses attributable to willful misconduct of assured. We cannot cover moral hazard of any insured. So if any willful misconduct due to any willful misconduct of the insured, there is any loss or damage to the cargo, it is not covered. Ordinary leakage, ordinary loss in weight, volume, ordinary wear and tear of the subject matter insured, it is also not covered. Loss, damage or expenses caused by insufficiency or unsuitability of packing, preparation of the subject matter insured to withstand the ordinary incident of the insured transit where such packing or preparation is carried out by the assured or their employees or prior to attachment of the insurance is also not covered. Now the first exclusion 4.1, it is concerned with moral hazard. And now this exclusion particular 4.3 is concerned with moral hazard of the insured. Moral hazard and moral hazard is different. Moral hazard is concerned with integrity of the insured. Moral hazard is concerned with attitude of the insured. Okay, so this 4.3 exclusion says that it is concerned with moral hazard of the insured. It says that just because you have obtained an insurance policy, you are not discharged from your duty to safeguard your goods, your cargo. So even if you have obtained an insurance policy, you are supposed to pack your cargo sufficiently enough, suitably enough to withstand the ordinary course of transit, ordinary perils of the transit. You cannot take a plea that since I have taken an insurance policy, I'm not supposed to, expense towards this packaging and all that. No, the duty will still be there. and you are supposed to pack your cargo suitably and sufficiently enough to withstand the ordinary perils of the transit. If you are failed to comply with the requirement of this exclusion, the insurance company will be discharged from the liability. However, to invoke this exclusion, the 2 points are very important. The points are, first, the packing was done by the insured. If the packing was not done by the insured or insured's employee, you cannot invoke these exclusion. The packing was done by the insured and it was done before commencement of the transit or prior to attachment of the insurance. So if in case of these two scenarios, you can invoke this exclusion. If your insured is importing any consignment from overseas and packing is done by his consignor, his seller who is residing overseas, he has done insufficient packing, unsuitable packing, and there is a loss or damage due to insufficient or unsuitability of packing, then you cannot invoke this exclusion and you cannot held responsible your insured who is not liable for the packaging, and you have to pay the claim. Okay, if goods are shipped under full container load, FCL, where stowing inside the container was done by the assured, this exclusion can be invoked against the insured. If goods are shipped as LCL, that is less than container load, where stowing inside a container is usually done by the shipping line, the exclusion cannot be invoked against the innocent insured. Now, in this exclusion, there is a clarification regarding packaging. What can be termed as packaging? So for the purpose of this clause, packing shall be deemed to include stowage inside a container, and employees shall not include independent contractor. So not only the basic packaging, if the goods are packed in crates or corrugated boxes or wooden pallets, not only that packing is considered as packaging, but if it is a containerized cargo, then stowing inside a container is also called packing. It will also be considered as packing. So if there is a loss or damage due to jerk and jolts, which can be attributable to bad stowing inside a container, improper stowing inside a container, you can still invoke this exclusion. Okay, so usually there are two types of container load: FCL, that is full container load, and LCL, that is less than container load. What happens in FCL is when you want to ship an FCL consignment, that is full container load consignment, you will ask the shipping line or shipping company to send you the empty container with the seals. So the shipping line will send you the empty container. You will open the container. You will do the entire stowing operation inside the container. You will close the doors of the container. You will apply the seal. The seal, which the seal number will be mentioned in bill of lading as well. Okay, so you will apply the seal inside the container. You will apply the seal on the locks of the container. Okay, so if there is a loss or damage due to improper stowing inside the container, you can invoke these exclusion because you as an insured has done stowing inside the container. But in case of LCL, what happens in LCL? You will send your goods directly to the shipping line. Okay, and the shipping line will do the stowing operation inside a container. So in a single container, there will be goods or cargo of multiple parties. In case of FCL, full container load, inside the container, there will be one party involved whose goods or cargo are stored in the container. Okay, but in case of LCL, inside a container, there will be multiple parties involved whose goods are stored in a container. The shipping line or shipping company will do the stowing operation inside the container. The shipping line will close the door. He will apply the locks. He will apply the manifested seals on the locks, and then he will send the goods. In that case, if there is a loss or damage due to improper stowing inside a container, then you cannot invoke this exclusion because the insured has not done the stowing operation inside the container. Loss, damage, or expenses caused by inherent vice or nature of the subject matter insured, it is also excluded. Loss, damage, or expenses caused by delay, even though delay be caused by a risk insured against, except expenses payable under clause 2 above. So loss, damage, or expenses caused by delay, even though the delay be caused by risk insured against, it is not payable. So if you are shipping your goods of mangoes or fruits or other any perishable items, if the vessel was being stranded, grounded, sunk, or capsized, I mean the vessel was grounded, and to refloat the vessel there was a delay of say 1 month or 2 months in the salvage operation, and the vessel was refloated after 2 months. When the perishable goods arrived at the destination, you have observed that the goods are damaged or the goods have deteriorated due to delay. Now the delay has caused due to an insured peril, but still the loss is not payable by virtue of this exclusion. So loss, damage, or expenses caused by delay, even though delay be caused by a risk insured against, is not payable. 4.6 is simple. Loss, damage, or expenses caused by insolvency or financial default of owners, managers, charterers, or operators of the vessel, where at the time of loading of subject matter insured on board the vessel, the assured are aware, or in the ordinary course of business should be aware that such insolvency or financial default could prevent the normal prosecution of voyage. This exclusion shall not apply where the contract of insurance has been assigned to the party claiming hereunder who has brought or agreed to by the subject matter insured in good faith or binding contract. Exclusion 4.7 in ICC-B and ICC-C, it says deliberate damage or deliberate destruction of the subject matter insured or any part thereof by a wrongful act of any person or person. In simple, it is malicious damage. So malicious damage is not covered under ICC-B and ICC-C. So it is an additional general exclusion 4.7 under ICC-B and C. You will not find this exclusion under ICCA. So since there is no exclusion of malicious damage under ICCA, it is considered as covered. Exclusion 4.8 under ICC-B and C, and exclusion 4.7 in ICCA. That is loss, damage, or expenses directly, indirectly caused by or arising from the use of any weapon or device employing atomic or nuclear fission or other like reaction or radioactive force or matter. It is an uninsurable peril. That's why we do not cover this peril. Section 5, exclusion 5 or clause 5 is unseaworthiness, unfitness exclusion. It is identical to your seaworthiness warranty, the implied warranty of seaworthiness under Marine Insurance Act. Now this is interesting. The war exclusion under ICC A and war exclusion under ICC B and C. What is the difference? Although the entire exclusion is identical in both the clauses, ICC B and C, there is one difference of this: piracy accepted. This phrase, piracy accepted. Okay, so ICCA being all risk in nature, where anything is covered except those excluded perils. Now this is an exclusion in ICCA, and we have exclusion in exclusion. Okay, so we have exclusion in exclusion. That means it is a covered peril. So piracy is covered under ICCA and piracy is not covered under ICCB. So, and as far as all risk policy is covered, an exception to the exception makes it an inclusion or an included peril. So war exclusion clause under ICCA says war, civil war, revolution, rebellion, insurrection, civil strife arising therefrom, or any hostile act by or against a belligerent power, it is excluded. Capture, seizure, arrest, restraint, or detainment. So, except piracy, piracy is a kind of detainment only. So piracy can be termed as detainment. So detainment is excluded under war exclusion, but piracy is an exclusion to detainment exclusion. That means other than piracy, all other type of detainment are covered, are excluded under war exclusion. So since piracy, other than piracy, all other detainment are excluded, piracy is deemed as covered. That is the reason you will find that question whether the piracy is covered under ICC A, B, or C or not. So under ICC A, it is covered. Why it is covered? By virtue of this phrase, piracy accepted. You will not find this phrase after the word detainment in ICC B and C clauses. That is the reason why piracy is not excluded in ICC. Derelict mines, torpedoes, bombs, and other derelict weapons of the war. Okay, so the rest of the exclusions are identical. Now, one may wonder if we incorporate institute war clauses along with ICC-B or ICC-C perils, whether piracy will be covered or not under ICC-B or C perils. That will be the question. So obviously, war exclusion is by default excluded. War exclusion is there in ICC-B and C. But along with ICC-B and C, if we incorporate institute war clauses, whether piracy be covered under ICC-B or not, we'll discuss this question subsequently. Okay. Strike exclusion. In no case this insurance covers loss or damage. Now, strike exclusions. Caused by strikers, locked out workmen or persons taking part in labor disturbances, riots or civil commotions resulting from strikes, lockouts, labor disturbances, riots or civil commotions caused by any act of terrorism and caused by any person acting from a political, ideological or religious motive. Okay. Transit clause. Now, this is a very important clause in ICC A, B, and C. When does the cover attaches and when does the cover terminate? Subject to clause 11 below, this insurance attaches from the time subject matter insured is first moved in the warehouse or place of storage at the place named in the contract of insurance. So this is the biggest difference between the version 1982 and 2009. In the 1982, the wording of the clause was like when the goods leave the place of storage or warehouse. So the initial loading was not covered. The initial loading was not covered. Here, the initial loading is also covered because when the goods or subject matter insured is first moved in the warehouse or at the place of storage for the purpose of immediate loading into or onto the carrying vehicle or other conveyance for the commencement of transit, So the initial loading is also covered. Continues during the ordinary course of transit and terminates either on completion of unloading from the carrying vehicle. Now, this is again one of the significant changes from the 1982 version, which we find in 2009 version of clauses. On completion of unloading from the carrying vehicle. The earlier version says when the vehicle reaches the warehouse, final destination. Now the word was reach. And here the word is on completion of unloading from the carrying vehicle. So after completion of unloading, the cover terminates. Therefore, the final or the last discharge is also covered. The last unloading is also covered in 2009 version of clauses. On completion of unloading from carrying vehicle or other conveyance in or at any other warehouse or place of storage, whether prior to or at the destination named in the contract of insurance, which the assured or their employees elect to use, either for storage other than the ordinary course of transit or for allocation of or distribution. When the assured or their employees elects to use any carrying vehicle or other conveyance or any container for storage other than in ordinary course of transit. This principle of marine cargo insurance is very simple. For example, your goods are being transported from point A to point B. Okay. During the entire transit, whenever you as an insured, you control the transit, the cover will suspended or the cover will terminate. Okay. And during the entire transit, when the goods are beyond your control, when they are under the care and custody of the transporter, the carrier, the cover will be in force. It is as simple as that. So when the assured or their employees elect to use any carrying vehicle or other conveyance or any container for storage other than in ordinary course of transit, the insurance cover terminates. Okay. So any storage which is any cover which is any storage which is incidental to transit is by default covered, but any storage which is not incidental to transit, which is not in ordinary course of transit, is not covered. Okay. On expiry of 60 days after completion of discharge overside of the subject matter insured from the overseas vessel at the final port of discharge, whichever first occurred. So this is the transit clause. Termination of contract of carriage clause, change of voyage clause. These clauses are of no significance or of little significance as far as examination is concerned. So we will skip this. Insurable interest, we have already discussed this principle of insurable interest.
Excuse me, sir.
Pardon?
Sir, I have a small doubt there.
Yes.
Hello. So normally, sir, in ICCA,
Okay.
so as far as ICCB is concerned, we have some points which we cover. So we have also have ITC, inland transit also. So
ICC?
normally, and this ITC. We have, for inland transportation, we have ITC process.
Okay, okay. Inland transit clause. Okay.
So normally, when we say about ICCB or C, it covers from warehouse to warehouse. So my doubt is that suppose the item or cargo is transported from a warehouse to a ship. So it includes
your voice is not. Wait a minute.
Okay, it's not clear, sir.
Hello.
Hello. Hello.
Hello.
Yes, sir. I am audible, sir.
Wait. Let me plug in the earphone. Yes, sir. Please repeat your query.
Sir. So normally this ICCB and C, it covers a warehouse to warehouse. for the
Okay.
cargo.
Okay.
So suppose one cargo is it is transported from a warehouse somewhere in internal part of
Okay.
India. The site is not put. That
Okay.
item has to be transported to a foreign
Okay.
country. So the
Okay.
sellers take the ICC B and C, either B or C.
Okay.
So does the ICC
Okay.
B or C covers this internal, Indian transit also, or should they take another ICC clause for Indian transportation?
Can you please once again repeat your query? Sorry, the voice is breaking actually.
My only question is that for inland transportation, sir, suppose the item has to be transported
Okay,
from
inland
Nagpur to
transit.
Mumbai, from Nagpur to Mumbai, and
Okay,
finally
Nagpur
from
to
Mumbai
Mumbai.
to the ship,
Okay.
and from ship it will go to voyage to Europe. So if the seller takes
Okay.
this
To Europe. Okay.
ICC B or C, so is this inland transport covered? Because normally we say this it is warehouse to warehouse.
Yes, yes, yes,
Insurance.
yes. Inland, no. Inland transit is covered. Yes, bilkul. Yes.
Covered, sir?
From
Because
your
we have ITC
Nagpur to
clause also,
Mumbai
sir.
port, no, ITC, look, have you read the heading of ITC clauses? It says inland transit clause not in conjunction with overseas transit. This is the entire wording. In bracket, there is a phrase not in conjunction with overseas transit. Okay. So ITC clauses are exclusively for those inland transit which are not in conjunction with overseas transit. Okay.
Okay, okay, sir.
Okay. I'll take 2 minutes. Okay.
Good.
Okay. So any queries so far regarding these ICC ABC clause? Hello. Okay. Now the forwarding charges. Okay. Where as a result of operation of a risk covered by this insurance, the insured transit is terminated at a port or place other than that to which subject matter insured is covered under this insurance. The insurer will reimburse the assured for any extra charges properly and reasonably incurred in unloading, storing, forwarding the subject matter insured to the destination to which it is insured. Clause 12, which does not apply to general average or salvage charges, shall be subject to exclusion contained in clause 4, 5, 6, and 7 above, shall not include charges arising from fault, negligence, insolvency, or financial default of assured or their employees. So, forwarding charges are also payable when the goods are not actually destroyed. So, what are the forwarding charges? The expenses properly and reasonably incurred in unloading, storing, and forwarding the subject matter insured to the destination. These are called the forwarding charges. So, now we look at that remaining peril, this particular peril. Discharge of cargo at a port of distress. So what is port of distress? Any port short of a port of destination, that is any port before the port of destination to which the goods are discharged due to some maritime perils, because the vessel has encountered any problems and the vessel cannot complete the journey. Therefore, they have to discharge the entire cargo at a port which is short of the destination port. That particular port is called port of distress. So when the goods are discharged at a port of distress, you will incur some expenses regarding unloading of goods, storing of goods, and then re-forwarding the goods to the destination. So those expenses are called forwarding charges. So forwarding charges are payable only if they are incurred due to an insured peril. So that's why we have that insured peril of discharge of cargo at a port of distress. So where as a result of operation of a risk covered by this insurance. Now discharge of cargo at a port of distress is a risk covered by this insurance. And as an operation of that peril, when you incur some expenses of unloading, storing, and forwarding the subject matter insured to the destination, they are payable. Even if the goods are not destroyed or damaged, they are payable by virtue of the forwarding charges. Okay. So this is forwarding charges. Now we have clause 16, which is minimizing losses, duty of assured clause, sue and labor charges. It is the duty of the assured and their employees and agents in the respect of loss recoverable hereunder to take such measures as may be reasonable for the purpose of averting or minimizing such loss, and to ensure that all rights against carriers, bailies, and other third parties are properly preserved and exercised. And the insurer will, in addition to any loss recoverable hereunder, reimburse the assured for any charges properly and reasonably incurred in pursuance of this duty. So these are called sue and labor charges as well, meaning loss minimization expenses incurred by the insured by virtue of duty of assured clause. Always remember, sue and labor charges are payable in addition to any claim, even a total loss claim. They are payable in addition to even a total loss claim. Okay. Now, what is the difference between sue and labor charges and salvage charges? If someone can explain, what is the difference between sue and labor charges and salvage charges? Because both are required. Sorry?
Sue and labor charges, I think they are the charges, they are actual charges to minimize
Pardon?
the damage further.
To minimize the?
To minimize the damage further. Normally it happens.
To avert or so we also incurred salvage charges to avert or minimize the loss. Salvage charges are incurred for that purpose only, so that we can avert or minimize the loss.
Okay. Salvage charges, right, sir.
Huh?
You're right. You're right.
So what is the difference? What is the difference between
is at short of destination.
Sorry?
Sue and labor charges are when occurs before reaching destination. It is short of destination.
Okay, so salvage charges are also incurred short of destination. We have already seen the example of ever given vessel, right? It has not reached the destination. So salvage charges are also incurred short of destination.
Salvage charges given to third party, and sue and labor are given to the insured party, whose means carriers employees,
Look,
crew members.
insured will also incur fuel labor charges to some third party as well, right? If he has incurred he has taken such measures for the purpose of averting or minimizing loss, he must have engaged some third party, right? The only difference is, as far as fuel labor charges is concerned, only the cargo of insured was subject to imminent threat or peril. As far as salvage charges are concerned, entire adventure was under threat. This is the difference. This is the only difference. Okay. For salvage charges, for general average charges to become payable, the entire adventure, the entire vessel, the entire ship was under threat. For fuel labor charges, only the insured cargo was under threat. And for who will incur salvage charges? Shipping line, shipping company will incur the salvage charges because the entire adventure was under threat. Who will incur fuel labor charges? Insured himself will incur fuel labor charges. Why? Because his own cargo was only subject to threat. You got the difference between fuel labor charges and salvage charges? Okay. Other than that, there is no difference. They both are incurred for averting or minimizing loss. They both are incurred short of destination. Okay. They both involve third parties. Other than that, there is no difference. Now we have institute war clauses. Okay. This insurance covers except as excluded by the provision of clause 3 and 4 below, loss of or damage to the subject matter insured caused by war, civil revolution, rebellion, insurrection, civil strife arising therefrom, or any hostile act by or against a belligerent power. Capture, seizure, arrest, restraint, or detainment arising from risk covered under 1.1 above and the consequence thereof, or any attempt thereat. Derelict mine, torpedoes, bombs, or other derelict weapons of war. Okay. So this is the cover available under Institute War Clauses. More or less, we carve back all the exclusions, more or less, not exactly, but more or less, we carve back the exclusions which are mentioned under clause 6 of ICC A, B, and C. Okay, got the point? Now, that question. By incorporating Institute War Clause along with ICC B or ICC C, whether the piracy risk will be covered or not? The answer is no. The piracy
it is covered only with A.
Yes, it will always be covered with A. Even if you incorporate Institute War Clause along with ICC B or C, it will still not be covered because detainment due to risk covered under 1.1 only is covered. So detainment due to war, detainment due to civil war, detainment due to revolution, rebellion, insurrection, or civil strife only is covered. Not all type of detainments are covered. So piracy does not fall under any of the definition of this peril. That is the reason, even after incorporating Institute War Clauses along with ICC B and C, the piracy risk will still be excluded and it will not be covered unless otherwise you specifically mention that ICC B plus war and SLCC plus piracy. If you explicitly mention the piracy risk, then only it will be covered in ICC B. Okay. Exclusions are identical, except this: any claim based upon loss of or frustration of voyage or adventure. This is the additional exclusion under ICC War Clauses. The remaining 7 exclusions are identical to ICC A clause. This is the additional exclusion: any claim based upon loss of or damage to the or frustration of voyage or adventure. What does this exclusion say? always remember the purpose of institute work clauses as well as institute strike clauses. The only purpose, the only intent of these two clauses is to cover actual physical loss. That's it. There has to be actual physical loss. That is not the purpose or intent under ICC A, B, and C clauses. We have already seen that there are many cases in which your goods are not damaged at all, but you will still get the claim. Under both to blame collision clause, you will get the claim because you have contributed towards BTBC clause. Under salvage charges, general average contribution, you will still get the claim under ICCB and ICCA and C perils. Although your goods are intact, although your goods are not damaged or destroyed, you will still get the claim. But that is not the intention. That is not the case here under institute war clauses and institute strike clauses. Okay. So if your goods are not damaged, if your goods are intact, they are in sound condition, and if you still incur some expenses, they are not payable. So any claim based upon loss of or frustration of the voyage or adventure, that means forwarding charges are payable under ICC ABC clauses, but forwarding charges are not payable under institute war clauses. Because when you incur the forwarding charges, your goods are in sound condition, they are in intact conditions. You have incurred expenses towards unloading, storing, and re-forwarding the goods. They are not payable under institute war clausing. So due to war perils, if there is a frustration of voyage, the vessel has terminated its transit at a port of distress, and you incurred expenses due to unloading, storing, and re-forwarding the goods, they are not payable under war clauses. Institute war clauses, the transit clause is very much explained in IC 67 books, so I'm not repeating here. Institute strike clauses. This insurance covers, except as excluded, the provision of clause 4 below, loss of or damage to the subject matter insured caused by strikes, locked out workmen, or person taking part in labor disturbance, riots, or civil commotion, any act of terrorism, and any person acting from a political, ideological, or religious motive. So again, we are carving back all the exclusions, more or less all the exclusions. We have already excluded under clause 7 of ICC A, B, and C parallels. So they are covered here under institute strike clauses. General exclusion. Loss, damage, or expenses arising from absence, shortage, or withholding of labor of any description whatsoever resulting from any strike, lockout, labor disturbance, riots, or civil commotion. Can you explain what is the difference between risk covered and risk excluded? Here it says that loss or damage to the subject matter insured caused by strikers, lockout, workmen, or person taking part in labor disturbance, riots, or civil commotion. And here it excludes loss, damage, or expenses arising from absence, shortage, or withholding of labor of any description whatsoever resulting from any strike, lockout, labor disturbance, riots, or civil commotion. They both seem identical. Then what is covered and what is excluded? Again, the intent is to cover actual physical visible loss. Okay. If you have incurred any extra expenses, for example, usually the labor charges 100 rupees for loading of goods on a vessel. Okay. So labor charges rupees 100. Now there is strike or there is labor disturbance at the port premises. So there is absence, there is shortage, or there is withholding of labor. So you have to arrange labor from outside the port premises. You have arranged labor from outside the port premises, and of course they are not going to charge normal labor rate. They will charge extra money from you. So instead of 100 rupees, they have charged you 150 rupees. So you have incurred 50 rupees extra due to shortage, absence, and withholding of labor, due to strike or lockout or labor disturbance, whatever be the reason, you have incurred that 50 rupees extra. You cannot claim that 50 rupees extra from the insurance company saying that I have incurred this 50 rupees extra due to a strike or labor disturbance. No, because your goods are intact. Your goods are still in sound conditions. Again, always remember the purpose of war clauses and strike clauses is to cover only the actual physical loss or damage to the cargo involved. Any extra expenses, any extra charges associated or incurred by you due to war and strike perils, they are not payable as long as your goods or your cargo are in intact and sound condition. It is the simple principle of both the clauses. Okay. Any claim based upon loss of or frustration of voyage or adventure, again, we have already discussed in war clauses. Loss, damage, or expenses caused by war, civil war, or revolution. It is same as war exclusion. Institute cargo clauses air. Unlike sea mode of transit for air mode, there is only one clause, that is institute cargo clauses air. Now, in this year's examination of officers from scale 1 to scale 5, there is a question that for air mode of transit, which is the which clause is available, and the options were institute cargo clauses air, and other option was institute cargo clauses air A. I mean, I have discussed with many of the students or who have appeared in the examinations, and they have said that we have marked institute cargo clauses air A because it is all risk cover. No, there is no such thing as institute cargo clauses air A. There is one clause, that is institute cargo clauses air 1/2009, excluding sendings by post. We have there is only one clause. It is all risk in nature, in line with ICCA. There is no general average or boat to blame collision clause because these two principles, principle of general average and boat to blame collision clause, is concerned only with sea mode of transit and not for air mode. So they will not appear in institute cargo clause air. Transit clause is similar. However, the time duration has been reduced to 30 days from 60 days as compared to ICC ABC clause. Institute classification clause is also more very important from the exam perspective. We incorporate this clause to safeguard our interest, because nowadays we are providing blanket policies like open cover agreement, open policy, annual sales turnover policy. We do not have information of a vessel at the time of issuance of policy, that on which type of vessel the goods will be loaded, whether the vessel will be in a seaworthy condition or not. So to safeguard our interest, we incorporate this institute classification clause that you have to the cover will only be applied if the cargoes or interest are loaded on a vessel which is in compliance with this clause, institute classification clause. Okay. Compliance is of two nature. First, it has to be a classed vessel by International Association of Classification Society, member or associate member of IACS, and this is the age criteria, that the vessel should be less than, even if it is classified vessel, the age limit should be within this prescribed limit. Okay. This is institute classification clause. Any questions so far? Any doubts?
Regarding port of distress.
Port of distress, yes. Okay.
Actually, which port is it can be considered as a port of distress? So it is where the ship is diverted, or it is the port of destination?
No, port of distress cannot be port of destination. Port of distress must be other than port of destination.
Okay, sir. Suppose
Sorry?
the ship is going to, suppose the ship is going to this Muscat.
Okay.
And something happened at the sea. I mean, something happened at Muscat, that there is a strike or there is a failure of
Okay.
some machinery or cranes in the Muscat.
Okay.
So the ship is diverted to
Uh,
Djibouti.
Now
So-
that is a different issue. That is a different issue. That will be considered as a change of destination. Change of destination, and that will be governed by clause number 9. Now I will show you the clause number 9. Okay, actually it was not important, so we have skipped that. Okay, sorry, clause number 10, not clause number 9, clause 10. Change of voyage. That is a different issue. Okay, so where after attachment of this insurance, the destination is changed by the assured. You are talking about this scenario, right?
Yes, so basically, but this port of distress has to be clarified. I thought that something happened in a port, and because of that reason, the ship is not able to discharge
The destination is
cargo.
changed. Yes.
Okay.
So they have changed the
Port of distress,
destination.
there is no question. So in this case, there is no question of port of distress.
Yes, that is not the question of port of distress. Wait a minute.
This term distress is quite confusing, sir. I thought something mishappening is happened in the port. So that's why it become port of distress.
Wait. So the concept of port of distress is completely different. Port of distress means the vessel has completed the journey at a port short of a port of destination. That is called port of destination. That means the shipping line has said that, look, my journey is over here. I'm not going to go forward, and I'm going to discharge all the cargoes at this port. That is called port of destination. Now your query is, you have diverted the vessel to other destination, correct?
Yes, sir.
That means the destination is changed. The voyage is not frustrated. The voyage is still going on, but the destination is changed. Okay. So that will not be considered as a port of distress. That will be considered as change of voyage. And that will be governed by this clause, clause number 10, change of voyage. Okay. Any other question?
Sir, this SRCC, is it same as RSMD?
Sorry?
That is a SRCC clause. Is it same as RSMD, sir?
RSMD, which we give along with burglary policy.
Okay,
Right,
so
strikes and malicious damage, right?
Yeah, in fire policy, it is one of the peril, RSMD.
No. It is not exactly identical, because strike clauses also cover terrorism peril. Okay. In strike clauses, you also cover terrorism peril. RSMD does not cover terrorism peril.
Right, sir. So that means they both are different. They're not same.
Yes, to some extent, yes, they are different. As far as the riots part is concerned, for example, as strike clauses does not cover malicious damage. RSMD peril covers malicious damage. Okay. Malicious damage is different from riots. What is malicious damage? It's when you have enmity with some person, there is personal grudge, personal enmity with someone. Okay. And with malicious intent, he has damaged your goods, right? That is called malicious damage.
But ICCA covers this malicious damage.
ICCA covers malicious damage. I'm talking about strike clauses. Strike clauses does not cover malicious damage.
Right, sir.
Strike clauses Wait a minute. Huh. This is strike clause. The strike clause does not cover malicious damage. It covers riots, strikes, locked out workmen, civil commotion, etc. So for this part, you can say it is common. Riots and civil commotion, it is and strike part, it is identical to RSMD. But MD, that is malicious damage, is not covered under strike clause. And terrorism, which is covered here. Look, by virtue of 1.2, terrorism is covered under strike clauses, which is excluded under RSMD, right?
Right, sir.
Okay, okay. Any other question? Okay. So we'll now look at the type of marine cargo insurance policy. Specific voyage policy. It is issued for a specific transit. It is a stamped policy document. Well, it's not a blanket policy. It is all issued for a specific transit. The insured is supposed to get approval from or negotiate with the insurance company before commencement of each and every transit. Is suitable for inland transit as well as import or export transit. The policy period is in line with the duration clause incorporated in the policy. The policy is usually freely assignable. The policy is valued policy, and the policy is not subject to adjustment clause. That means even if the transit not actually takes place, there is usually no refund provision or no adjustment clause under the specific voyage policy. So this is specific voyage policy. Now this is open policy. It is a blanket policy. Okay. It is given to the insured on a blanket basis, that is on a 12 months basis. The insured is relieved from the hustle of arranging insurance before each and every dispatch. Okay, the policy is usually for 12 months or till the exhaustion of sum insured, whichever is occurred earlier. So even if the 12 months are not completed, if the sum insured has been exhausted by virtue of periodical declaration, then the policy is also terminates. The insured and the insurer agrees for the terms of the policy at the time of issuance of the policy. So these are the terms and conditions for which the insured and the insurance company agrees, and commodity to be insured, territorial jurisdiction, transit from, transit to, excluded and sanctioned areas to which the cover will not be available, mode of transit, rail, road, sea, air, sum insured, per bond limit, per location limit. Okay, so what will be the maximum liability of an insurance company per transit or per conveyance? That will be decided beforehand. Per location limit, what will be the maximum liability of insurance company for any one location? That will also be decided. What will be the coverage, exclusions, rate of premium, basis of valuation, terms, conditions, policy access. After issuance of policy, the insurer is obliged to accept, and the insured is obliged to declare each and every consignment falling under the scope of the policy coverage. This is the property, or this is the provision due to which we call it a blanket policy. Why it is a blanket policy? Because once the insurance company has agreed for an open policy, he is obliged to accept each and every consignment falling under the scope of the policy coverage. In a specific voyage policy, the insurance company has a liberty to decline the proposal. That, look, I'm not going to quote for this proposal form, I'm declining this proposal, I'm not going to accept this. In an open policy, each and every consignment which falls under the policy coverage, the insurance company has to accept that consignment. That's why it is called a blanket policy. The declaration must explicitly mention all the relevant particulars pertaining to the consignments dispatched during the concerned period. Invoice number, date, lorry receipt number, date, name of consignment, etc. if the insured fails to declare all the consignment falling under the scope of policy coverage, the policy may become voidable. The sum insured under the policy stands reduced by each periodical declaration. The insured has option to enhance the sum insured before it gets exhausted. It is a stamped policy. The policy is more suitable for covering inland transit because in inland transit, during inland transit, there is no requirement of insurance certificate. So that is the reason why this policy is more suitable for inland transit. The policy is subject to adjustment clause. However, only downward adjustment is permissible. No upward adjustment is permissible. Only downward adjustment is permissible. Okay. So if your there is a sum insured of 100 crore in the policy, and after expiry of the policy, the total turnover was 105 crore. So you cannot make upward revision in the policy. There are policies for which upward revision is permissible. For example, WC policies. So in the WC policy, during wage adjustment, you can easily do upward revision. If the wages mentioned in the policy are lower than the actual wages after the policy, after the completion of policy, you can easily make upward revision. Then there is a adjustment clause under cash in transit or money insurance policy, section 1 money insurance policy or cash in transit policy. So there we use the word estimated annual turnover. The word is estimated annual turnover. So at the time of loss, if the actual turnover of cash in transit is more than the estimated turnover mentioned in the policy, the claim will still be payable because the upward revision is permissible. That is the reason why the claim is payable. But that upward revision is not permissible here. Only downward revision is permissible. The policy is usually assignable. The policy is usually valued policy. Open cover agreement. Again, this is a blanket policy. The insured and the insurer agrees for the terms of the agreement at the time of issuance of the policy. Open cover certificate being issued under the open cover agreement are stamped policies. The insured maintains a cash deposit or advance premium deposit account with the insurer for issuance of the open cover certificate as and when required. After issuance of the agreement, the insurer is obliged to accept, and the insured is obliged to declare each and every consignment falling under the scope of the agreement. Okay. The policy is more suitable for import and export because while importing and exporting, during the custom clearance formality, a person needs an insurance certificate. Okay, so mere open policy will not be sufficient because the open policy does not mention transit particulars. Transit from, transit to, invoice number, bill of lading number, then letter of credit number. All these transit related particulars are not mentioned in an open policy because open policy is of a generic nature. So we need a certificate for custom formalities. That is the reason why open cover agreements are very suitable for imports and exports. There is no need for adjustment because no consideration was paid by the insured at the time of issuance of agreement. We have not collected any premium amount, so there is no question of adjustment of premium. Certificates are usually freely assignable. Certificates are usually valued policies. Annual sales turnover policy. Again, it is a blanket policy. Again, it is a blanket policy. It offers widest possible cover, and it covers all type of transit, domestic purchase, overseas imports, inter-depot transfer, job work transits, domestic sales, and overseas sales. These policies are also usually freely assignable. These are also valued policies. Annual policy. Now, annual policy and annual sales turnover policies are completely different. This policy, this particular annual policy is not freely assignable. Why? Because the policy is being issued for goods which are not under contract of sales or purchase. The particular policy, it is also called inter-depot policies. Okay, so the particular policy is issued for goods which are not under contract of sales or purchase. So there is no sale of goods or there is no purchase of goods. There is no buyer, there is no seller. So what is the need for assignment? There is only one particular party is involved. So the depot from which the transit commences and at which the transit ends must be owned, occupied, and hired by the insured. So I am sending my own goods from my one premises to my other premises. There is no transaction of sale or purchase. There is no seller, there is no buyer. So that is the reason why this policy is not assignable. There is no need for making any periodical declaration by the insured. The sum insured represents maximum value of goods on the risk at any one time during the policy period and remains constant in the event of no claim. However, the condition of average will apply. So if at the time of loss, the total value of goods in transit was higher than the sum insured, then the condition of average, that is the condition of underinsurance, will apply. Simply like any other form of insurance. The sum insured shall stand reinstated on a valid claim arising subject to payment of pro rata additional premium on the reinstated amount. Total liability of the insurer during the policy period shall not exceed twice the sum insured stated in the annual policy. Basis of valuation is prime cost plus expenses incidental to the transit and charges of insurance. The policy is not subject to adjustment clause. Then we have increased value insurance, duty insurance. These policies are also not assignable because these policies are affected on the import consignment only. So when you are importing a consignment and you are affecting this insurance policies, duty insurance or increased value insurance, there is also no need of any assignment because only one party is involved, that is important. Okay, he is interested in any increased value by virtue of fluctuation in value of the goods, or in case of custom duty, if he has paid advance custom duty and there is loss or damage to the consignment, then he will also lose the custom duty already paid to the custom authorities. So that is the reason why these policies are not assignable. These policies are also not valued policies. These are unvalued policy. We have already discussed. The liability of the insurance company will be restricted to the actual loss subject to sum insured. Maximum liability will always be the sum insured. Second thing, these two policies are also identical to, you can say, your fire loss of profit policies or consequential loss or business interruption insurance policy. Because in those policies, there is a material damage provision. We have the material damage provision here as well. What does the material damage provision say? It says that there has to be a corresponding material damage policy and the claim must be admitted there first. Then and then only the claim will be payable under these consequential policies. So that is the reason these are also called consequential policies, because there has to be corresponding material damage policy covering the CIF value of the cargo. Okay, the coverage must be identical under that CIF value policies and these increased value policy or duty insurance policy, and the claim must be admitted there first. If the claim is not admitted there, then the claim are also not payable under these policies, increased value and duty insurance policies. Seller's interest, seller's contingency policy. There are situations in which seller will continue to have an insurable interest though title to goods has passed to the buyer. For example, the seller of the goods on FOB or other terms under which title passes to the buyer at some point in transit will have a financial interest in the goods until payment has been received. So the policy covering seller's interest may be issued to valued clients only, issued for goods or consignment shipped on FOB and CFR or C&F Incoterms only. The policy covers physical loss or damage to the cargo insured subject to terms and conditions of the policy to protect only the interest of the insured mentioned therein. This insurance is not assignable. Of course, we have already discussed this policy under the contingent insurable interest section of Marine Insurance Act 1963. So it is a contingent insurable interest. After happening of a contingency, an insurable interest reattaches to the insurer. That is called contingent insurable interest. So this is the example of contingent insurable interest. So if the goods are sent on FOB and C&F basis, the insurable interest of seller terminates after the FOB point. And if the buyer who has not made the payment yet rejects the cargo because they are damaged, then the insurable interest will reattach it to the seller by virtue of this policy. So that is the reason why this policy is also not assignable. Warranted that the insured shall not change the terms of contract of sale relating the goods hereunder subsequent to the operation of a peril insured against for purpose of securing indemnity under the policy. Warranted that the insured shall safeguard all contractual and other rights against the buyers, carriers, and other parties concerned with the transactions and transport of the goods covered therein. Now there is one warranty which is called the warranty of secrecy. That warranty says the assured should not disclose to the consignee or any other party who may have interest in the insured goods but about the existence of this policy. So what happens is under C&F and FOB basis, there is no obligation on either party to arrange insurance on behalf of the other party. Okay. So usually seller insure his leg of journey, that is from his warehouse to FOB point, and the buyer insure his leg of journey, that is from FOB point to his warehouse. Both the insurers are different, both the journey legs are different, they are mutually exclusive, there is no overlapping. However, there is a warranty of secrecy that the seller should not disclose the existence of seller's interest policy to the buyer. That I have such and such type of policy. So, so that the buyer must claim any loss or damage from his insurance company. Again, this policy is on the principle of difference in condition. Now, what is difference in condition? Difference in condition means the contribution clause will not be applicable. So, any policy which is on difference in condition basis will only pay the claim over and above the claim payable under the other policy. So, for example, when the buyer has received the goods which are in damaged condition, usually there will be two policies which will be effective simultaneously. That is the buyer's insurance policy as well as seller's contingency policy. Both will be effective simultaneously. So, in case of loss or damage, this policy will not be triggered simultaneously. The contribution clause will not be applicable. The claim will be first paid under the marine insurance policy of the buyer. If there is any amount which is not paid under that policy, so the amount over and above claim payable under the buyer's policy will be payable under the seller's contingency policy. This policy is non-contributory in nature. Okay, something like marine insurance clause under your fire policy, your general condition number 4 in SFSP policy. So if a property is covered under marine insurance policy, the claim will be paid there first, and any amount over and above claim payable under marine policy will be paid under the SFSP policy. So it is identical to that clause only. Buyer's contingency policy. So under CIF Incoterms, cost insurance and freight Incoterms, the obligation on the seller is to cover the consignment only for the ICCC perils. Okay. So if the seller arranges the insurance on behalf of buyer only for the ICCC perils, it is considered as compliance of obligation under CIF contract. Okay. Now, if the buyer wants to cover his consignment for all risk policy, he can also arrange the insurance for ICCA or ICCB or any other higher coverages. So this policy only covers the interest of buyer. That is the reason why this policy is also not assignable. Again, this policy comes with the secrecy of warranty. This policy is also non-contributory. That is, this policy will not contribute towards any other policy. If there is any amount which is not payable in the other policy, that can only be paid under this policy. Okay. This policy is also not assignable. So I guess we should conclude our lecture here. Because marine insurance being so vast in nature, it is literally impossible to cover the entire all the concepts of marine insurance in just a single session of 3 hours. I have tried my best to explain as much as possible. I guess we should go for 10 or 15 minutes of question and answer session. If you have any question, you can please ask. No questions from anyone?
Sir, one doubt is there, sir.
Yes, please.
So there are very expenses which is done by the shipping company. As you told, that there are poor labor charges and survey charges. So there are other charges, sir, like gross proceeds, net seller proceeds. So can you please explain, sir?
Sorry. What kind of charges?
Yes, not charges, it is expenses like gross proceeds, sellers, net seller proceeds, particular charges.
Okay. No, those are type of claims. Those are the type of losses. So particular average is nothing but partial loss. It is as simple as that. Particular average is a partial loss claim. So these terminologies were used in the British Marine Insurance Act, and so we have just simply replicated them. That's it. So particular average, particular charges. Look, when I say average, that means the cargo or good has been lost. When I say charges, that means although the cargo or the good is in sound or intact condition, but I have incurred some expenses to avert or minimize the losses. So for that kind of expenses, I will use the word charges. For when there is actual physical loss, I will use the word average. Okay. So it's particular average, particular charges. Done.
Okay, sir.
And the word particular denotes the term partial loss. Okay, so the goods are not totally lost. It is partially lost. Okay. Any other question? Okay, so we are concluding the session here. Thank you so much for your cooperation.
Thank you, sir.
Okay, thank you.